located?
Yes, Jason Capel, District 1. I'm located at 6315 Spotswood Trail in the lovely town of Gordonsville, Virginia. Go District 1.
Mr. Chairman, this is Tracy. May I interrupt for just one moment?
If I said you couldn't, what would happen?
I'd probably do it anyway.
You can, go ahead.
Caleb, you need to
That's what I
start
meant. Go ahead.
the live streaming. Caleb, have you started live streaming? Caleb?
Sorry, I had to unmute myself. Yes, the stream is good.
Good. Thank you. Thank you, Mr. Chairman.
Okay. So were we live streaming when Jason signed in, or were we not? Okay, let's just start again. Mr. Capel, identify yourself in the District 1 again, and we'll start in, one more time.
Yes, sir. Jason Capel, District 1, 6315 Spotswood Trail, Gordonsville, Virginia.
George Yancey, District 2. I'm located at 16170 Cox Mill Road, Gordonsville, Virginia, my residence.
District 3, Donald Brooks, the chairman at 9258 Alvarona Road, Unionville, Virginia.
District 4, Julie Zellmaker, 34104 Indiantown Road, Locust Grove, Virginia.
Jim Hutchison, District 5, 525 Harrison Circle, Locust Grove, Virginia.
Okay, thank you. It appears that all the commissioners are here, so we have a quorum, but just for identification purposes, we do have Sandra Thornton, our planning services manager. We have Tracy Newman, planning services clerk and administrative assistant. Do we have Mr. Johnson, District 1, our board rep? Okay, we do have Mr. Lansing, our county attorney. Did I miss anybody from the county staff that was attending or in attendance of the meeting? Okay, the Orange County Planning Commission holds this meeting. This meeting is being held electronically pursuant to and in compliance with the Continuity of Government Ordinance or an ordinance to effectuate changes in certain deadlines and to modify public meeting and public hearing practices and procedures to address the continuity operations associated with the COVID-19 pandemic. This was adopted April 28th, 2020 by the Orange County Board of Supervisors in accordance with Virginia Code 15.2-1413. The meeting is accessible by youtube.com/channel/UCNL EM-1LGR-XYD-FKCP18-60Q that can be found on the Orange County website. This meeting will be conducted remotely. There will be no physical public access during the meeting. There will be no opportunity for the public to comment. At this time, we will call the meeting to order because we have determined we have a quorum. I would ask the commissioners to, if they would, approval of the agenda as stated or changes if necessary.
So moved.
Make a motion. Seconded.
Moved and second. Seems like District 1 moved, District 5 second. For the approval of agenda is placed. I solicit an approval for the minutes of October 1, 2020 regular meeting.
Mr. Chairman, I think technically District 5 made the motion and District 1 seconded on the agenda.
Thank you for the correction. Tracy, did you get that?
Yes, sir.
And
Thank
District
you.
1 would make a motion to approve the minutes as presented.
And District 5 will second.
Okay, removal and approval of the minutes and agenda. I didn't carry the previous one, so let me carry the previous one, then I'll carry that one. All in favor, say aye for the approval of the agenda.
Aye.
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 All opposed would have the like thing. Now we will ask, I will carry the motion for the approval of the minutes. All in favor, say aye.
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 Any
Aye.
opposition? And I'm sorry, any opposition has the same right. Seems like it's approval for both of those. I do have one piece of new business. The Board of Supervisors met last Tuesday in person, and they have prepared a room to meet in person. So we look like we may be having our meetings in person with the guidance that they're using. I'm not telling us we have to go there. I'm just telling us what's available and what may be coming down the pike there for us. I would ask if anyone really has a real bad heartburn, call me after the meeting. I don't want to get into all that right now. And when I say after the meeting, I don't mean tonight, but just sometime, not that you can't call me tonight, but that sometime between now and the next meeting, if you have a lot of heartburn against that, and then we will discuss that out and play it out if necessary. Any questions? Thank you so much.
Mr. Chairman,
Looks like we got.
Mr. Chairman,
Yes.
if I may
Yes.
just add something to that, as you all think about how you want to meet, if we have matters to advertise for the November 5th meeting, that legal ad deadline is this coming Monday at noon. So if you want to consider changing how the meeting is conducted and where, I'll need to have that information before noon on Monday. If we have matters, I think there may be a couple of things that you schedule for November 5th.
Also,
That
Mr.
may be a point. Sure.
Also, Mr. Chairman, I gathered from that meeting on Tuesday, they were limited to 9 people in the audience.
Absolutely. And anywhere that we go or we do now, there's a limitation on folks. And I do also believe that they did some other screening processes before they allow people in, to include board members.
Mr. Chairman, Jason.
Go ahead.
Yeah, I mean, since we brought it up, I mean, I don't want to get in a long, dragged out discussion. It'll take me about 3 seconds to give you my opinion. My opinion is that the prudent thing to do would be to wait until January and reevaluate and continue to hold our meetings virtual until then. That's supported, I think, by evidence, and that's all I'll say on it. My opinion's not going to change on that. That's my personal opinion, is that we stay virtual and we reevaluate at the December meeting or perhaps the January meeting after we get through the weather change and all the family gatherings.
Okay. Points well taken. All right, any other new business? We have a continuation of 2 public hearings. 1A, the rezone 20-2, the Storeland LLC that we had from the last meeting, and the continuation of SUP 20-03, which is Storeland. And there were some questions we had. There were some ideas that were cast around and some different things. And so we're going to take up from where we left off. I will say that we would ask that before we get started, that Mrs. Thornton would be prepared to place into record the comments we got from the public, meaning they will be in a permanent part of our record. There's not a need to read, I understand, but there's a need to place it in record. Is that right, Sandra?
Yes, that is correct.
Okay,
And they will be attached to
So
the
we
minute, they will be
just-
attached to the minutes of the meeting.
right. Thank you so much. Now, Sandra, did you want to add anything to A and B, A or B? They kind of run together. I understand that, but let's try to keep them separate as much as possible. Did you want to add something to A and then we'll talk about B and then we'll see if the applicant has anything to add to A or B?
I didn't have any additional information, Mr. Chairman. I know, and I didn't address this in the staff comments a couple of weeks ago, and you have received, I think, summary statements from Mr. Hutchison based on a site visit he conducted. The topography of the parcels is kind of difficult and will require I'd say fairly significant engineering, but that's not to say that the development can't be done. Other than to acknowledge that, I don't have anything to add to the material that the applicants has submitted based on your discussion on the first.
Well, you went to one of the things that I was going to bring up, so since you brought it up, I'll ask. At this stage, though, if we approve this, they still have to fulfill the site management plan guidelines and all that also during this process, correct?
Oh, yes, they will have to go through the complete and usual site plan review process.
Okay, all right. Any commissioner have any other questions for staff at this time? Does the applicant have anything that they want to say at this time? If so, come forward, state your name and your position with the company if you're present.
Yeah, Steve McLean with Storeland LLC as one of the developers for the property. Just wanted to make sure see if there was any questions on what I had sent in.
Steve?
Answer your questions from last meeting.
All right, if you would just start one more time, state your full name and your address and your position with the company, and then move forward.
Okay, it's Stephen McLean, 516 Mount Pleasant Drive, Locust Grove, Virginia, and I own Storeland LLC.
Thank you. Continue.
Just wanted to check to see, make sure that everything I sent in was clear as far as the questions that were asked of me last meeting, and so that we could just move forward, and that the noise, everything about the noise considerations and the phasing were all clear to everybody.
Does anybody have any questions for the applicant?
Mr. McLean, this is Jim Hutchison, District 5. I walked that area. I will tell you that that is a significant, tough terrain to walk. When I did walk it, there were a series of blue and white striped plastic tags or markers throughout the area. Can you tell me what those are for?
I have not what to say. We had a surveyor in there doing a topo on it. Can I ask Kenny Dotson if he can answer that question?
Yeah, you can. Just get him to come forward, state his name, his address, and any affiliation he has with the company.
Okay. All right. Ken Dotson. I live at 33225 Constitution Highway, Locust Grove, Virginia. We're one of the partners with Steve and Wells Wall is another partner. So it's the three of us that are forming this partnership. Wells Wall and I right now currently own the property. The flags that you were asking about, some of those are topography. Some of those are wetland delineation flags, depending on where you were in relation to the creek area. Because again, that's been delineated. And that's reflective in the site plan that was submitted dated October 8th, 2020. So a lot of that was for that. I'm not sure which flags or what color, but the engineer's been out there doing the wetland delineation and the topo.
Yeah, I saw the wetland. They were the red marked with with wetland, and it looks like that property. I mean, one of the big concerns at Lake of the Woods is stormwater damage.
Mhm.
And I'm not sure that there's anything, and again, maybe Sandra has some input on this, that anything can be done for that wetland area because you can't touch it.
Right.
But I don't know whether the state can do anything to try and solve some of the drainage going down from that bridge underneath 20 all the way through Lake of the Woods. Plus the land itself slopes down to the southwest, which goes right into that wetland area and contributes. Are you going to try and mitigate some of that flow?
I tell you, the flow that's in that creek, it's really a drainage way. It's not even a creek. We consider it like an intermittent stream, whatever it rains. And the flow that's coming there is from VDOT coming off of Route 20 and going down through there. And that drainage swell's been there since all of us have been around. But just to elaborate on your question, we've had some dealings with DEQ. And what happens, what triggers, anytime you disturb property more than an acre, any ground more than an acre, the DEQ gets involved. And the DEQ regulations now, they regulate the water quality and the water quantity. And so what that means is the water leaving, anything we disturb, we're not going to disturb that creek at all. And we got to stay 35 foot off of it. So we really don't want to get into that just because of stabilization. But anything that we touch, we regrade. We've got to actually follow the DEQ regulations. So we can't dispose of any more water than was coming off that site. And it's at pre-existing conditions, which is wooded. So if that piece of property had been a field, the flow would have been greater than the tree property. So then we would have had a better flow rate off that property. Now we're actually restricted to the amount of flow because it's based on woods. So what I'm getting at is, if that makes sense to you, that the quantity can't be no more than what it is today when we do our stormwater retention. And the quality has got to be, because there's biofilters and everything now, it can't be worse than what it is today. And so that's the DEQ regulations, and we'll have to follow those through the state. And they will monitor us through the whole construction process.
Which is going to take some significant work on that property to
correct.
prevent that.
That's correct. It becomes expensive because of the lay of the land. But again, a good piece of flat land gets expensive anymore with the DEQ regulations.
Okay. One other question, and I don't know whether or not you've seen the letter submitted by the Lake of the Woods Association, have you?
I did, and I actually talked to the general manager today.
Okay, to Phil Rodenberg?
I did.
Yeah, one of the requests that they made, and when I walked that property, they wanted to request 60 feet instead of 50 feet spacing between the property line. Is that feasible?
It isn't, because back to you talking to stormwater retention, we need to utilize some of the land for underground retention. But I made a request of the general manager today asking that Lake of the Woods fence that property where the Lake of the Woods property line is, because it's the only piece of property that wraps miles and miles around Lake of the Woods that is not fenced. And so what I proposed to the general manager today was that, and again, he was going to talk to the board of directors about it, was that they would take and install the fence along our property line with them, like they've done the rest of the Lake of the Woods. We would take that 50-foot buffer area, undisturbed, not disturb 30 foot of it. And one of the reasons not disturb the 30 foot, be honest with you, I'd rather take all those trees out, because we've had over the years, because again, we've got a number of neighbors that border not only this property, but other property along, because we own other pieces adjacent to this. And some of the trees become a nuisance to the neighbors in Lake of the Woods. And we've actually gone out of our way to actually take down some of the trees before they fall on their property. So what's happened is some of these larger trees are entering into their lifespan. And so once we leave them, and once we build the storage buildings, and we've got this buffer, they can't get to it and we can't get to it. So these trees are going to fall, and whether they fall on us or fall on them, they're going to fall because they can't be maintained. So it'd been nice to actually clear the buffer, clear that buffer area and actually plant back a landscaping that would actually accommodate what we're trying to accomplish, which is screening the buildings. So what I proposed to the general manager was that we would leave a 30-foot buffer, that Lake of the Woods would run the fence along their part, because I don't think the people, again, we're trying to accommodate the citizens of Lake of the Woods. I don't think they want to look at a black fence, because we're looking to put up a black fence. So if they would take up and put their normal fence up that's around the perimeter of Lake Woods now, we would leave a 30-foot undisturbed buffer. We would take the next 20 feet and clear that, but at 10 foot out, we would plant Leland cypress approximately 10 to 12 feet apart. So they became a wall basically of those Leland cypress. And we had sent some pictures to the planning department so that you could see a piece of property that we have houses on both sides less than 35 feet apart, and you can't see the houses through those Leland cypress, and they're about 10 years old. So then by planting those at 40 feet, the Leland's got 10 feet to grow into the existing woods, and then it's got another 10 feet to grow into us, and we would put a black fence at 50 foot. So basically there'll be two fences. Lake Woods put their fence up, we put our fence up, and we've got a 50-foot buffer.
When did the general manager say he'd get back to you?
Again, I told him we were meeting with the plant. The problem I had, I didn't get you the package, these responses from the planning department till Tuesday late. And again, I've been trying to reach out and respond to some of these concerns. But again, he was going to reach out to the board of directors. Now, one reason, because they don't have it in their funding to put up the fence, is what he said. But I said, it really doesn't matter if it happens this year or next year. I think it needs to happen. It's never happened. And so we end up with some of the debris from Lake of the Woods when they clean their lots and their leaves and their dead trees. They kind of come on over and put some of that over there.
Yeah, when I walk through there, there's a whole bunch of downed trees that have fallen and rotted. There's lots of dead trees back there.
Yeah, and that's what happens when they're not maintained, and that's what's going to happen in that buffer area. And again, that's why we were trying to, again, not to minimize the trees, because we don't want a tree to fall on our building. And so that's why we're trying to keep it back a little bit and also accomplish with the Leland cypress and put a nice dense row of Leland cypress across there.
So pending the response from the general manager of the association, you'll adjust your site plan?
I don't think we're going to go, I'm not looking to go 60 feet. Again, I'm trying to make a fair compromise that we do, really the way the ordinance is written, it's a 50-foot setback. And
Right.
What happens with us doing the fence at 50 foot, we're still off of the fence another 10 or 20 feet. So we're going to be almost a 60 or 70-foot setback off of the property line. And the other thing is, I mean, the building, we've turned the buildings from left to right to actually add screening to Lake of the Woods, where before they were perpendicular. And if you look at the footage on the buildings, one's 200, one's 160, potentially you've got 400 feet of buffering by the buildings, and they're tan with green roofs. So we're doing all we can. We've taken everybody's concerns into consideration.
Okay. Well, is your response going to delay your project at all, waiting for his response?
No, because again, I think we understand what we're trying to do. It's at the planning commission level, and we still got to get to the board level in another month or so.
Right.
So we'll have time to adjust at that time, as long as the planning commission sees fit to move this forward. But again, we've tried to be responsive by turning the buildings. If you even notice the boat and RV storage, it's in front of those buildings. So we've screened those from the road and from Lake of the Woods for future buildings. Again, we've really tried to be accommodating and receptive to everybody's concerns.
Yeah, I appreciate all the accommodations that you've made, including the efforts to reduce the noise, et cetera. So, Mr. Chairman, I have no more questions.
Thank you. Mrs. Zillmaker, you have any questions?
No.
I don't have any questions. I do have a comment. It appears to me that the applicants have gone out of their way to accommodate, and I guess by the way of you, Mr. Hutchinson, how much property is not actually fenced by the Lake of the Woods that's not near this property? Do you know?
I don't know how much is, I know it's a significant amount because they've never decided to budget the fence line along that entire area back there because of the wooded area. So it's something they're going to have to deal
Because
with.
when I went back there, it's kind of hard to determine whose property stopped and started.
The survey
You know,
should do that.
say it again?
The survey should do that. Plus, if I remember correctly, there's a 1-foot easement on the outside of the Lake of the Woods property line, but the survey should determine where the property lines. It's really hard to define it back there when you walk back there because it is just, Kenny can probably tell you better than I can. It's just rough back there.
Yeah, it's not very habitable back there for foot. I can promise you. I've tried it.
It's terrible.
The ironic of that was, I remember that was the access way that folks would get into the Lake of the Woods when they wanted to make some mischief back in the day. They knew how to get through that unfenced area.
Well, the pictures
The
that
other question I
I
have for,
sent show Confederate Drive, and it shows the one major dip area where the water comes in, and that's an outflow coming off of the wetlands area that flows under Route 20. So I don't know what can be done about that, and it sounds like the contractor is going to do everything it can to ameliorate any additional flow, regardless of DEQ regulations that contribute to additional stormwater flow from the new design property going into that wetlands area. The wetlands area is the problem.
thank you. The other question to Steve or Ken, I don't care which one answers. How many of these noise ordinance signs are you planning putting up? The sign is very appropriate, but how many do you plan to put up?
We probably put like every, as you're going through there, one at the gate, and then about every 2 buildings, we put them on the corner so that along with us, with caution signs and everything else, we have a series of signs that we put up, and there'll probably be like 8 of them on site.
And the next question I have, you're gonna have all down lighting on these buildings? One of the letters of concern was that lights would come to their house. So all these lights will be down with pointing, correct?
Right. There'll be LEDs, so the light's a little bit different, and it's and also we're not going to be putting lights on both sides like of an alleyway. We're only going to be putting on one side of an alleyway, so there won't be as many lights as you see in a lot of storage facilities that you drive by where it's just lit up like daylight. It won't be like that at all.
Okay, thank you. Mr. Yancey, you have any questions?
Yes, I do. I commend Mr. Dodson and his cohorts in their efforts to work towards a resolution. The only question I have is, should the agreement be ratified between the Lake of the Woods Association and the partnership? Ultimately, you'll have 2 fences, which will basically be landlocked. Who is ultimately responsible for that property in terms of down trees or other issues that may occur?
The trees are our trees when they're standing. And of course, what happens for neighbors that have had trees fall on their neighbors or on their property from their neighbors, it becomes their problem. Because insurance, their homeowner's insurance will pick it up if it falls across the fence. So if the tree falls on us, we take care of it. If it goes beyond the fence line into Lake of the Woods, it becomes, ours is still to deal with to the fence. And then, in other words, say half the tree falls, we got to deal with half of it, and the owner would have to deal with half of it. It's just the way it works. And the problem is it's hard for us to get across there and take out fencing to fix that tree. It's an act of nature. And that's the problem too.
That's the standing position and law as it relates to everybody. I mean, it's just kind of how it does.
Yeah.
It doesn't change because they put in these buildings.
I have no further questions.
Mr. Capel?
Yeah, so first of all, thanks to the applicants. I looked at the plan and I noticed a number of changes, based on our last discussion, particularly moving the RV and vehicle storage internal. So I thought those were all really good changes, and thank you for that. Mr. Dotson, the fence situation that you described with Lake of the Woods, I mean, whether Lake of the Woods puts the fence there or not, that doesn't really hinder your plan one way or the other. Is that correct?
That's correct. We're just requesting that they would do it because that 50-foot would also, because their house backs are 35 foot off the property line. All of a sudden that landowner or homeowner may think that they got 50 foot to our fence. And so it'd be good if we
Right.
distinguish that. Yeah.
Yeah, I'm just pointing out if they say, hey, sorry, man, we're not putting the fence up. That's
Right.
not really, doesn't really affect your plan one way or the other.
It doesn't, but it would be
Yeah.
nice if they did.
Yeah. No, I got it. I don't think we can put a condition on someone else based on your zoning.
We've been a nice neighbor letting them come on over, but at some point now we need to shut it off.
Yeah. So the only other two things I have to do with the screening. The C2 zoning requires 50 feet, and it requires fence or landscape. I'm just reading it here to protect from any adverse impact. The single row of Leyland cypress, I mean, that's a good screening. Part of me thinks that, hear me out here, because I know some of the local folks who live there. Part of me thinks it would be better just to clear that 50-foot buffer and replant it with something more than one line of Leyland cypress, for a lot of the reasons that you're mentioning. I mean, there's trees falling, hitting your building. Yeah, I mean, insurance pays for it, but I mean, it is on your side, it's loss, income potentially for renting. Would there be any consideration to doing something more substantial than just the single row of Leyland cypress? I mean, would you see an advantage to clearing that buffer totally and doing a more comprehensive landscaping solution back there?
I don't see a problem with it. In fact, that's what we really wanted to try to do, but I know there's some concerns about leaving the existing trees. And of course, one concern, one thing about leaving the existing trees, you've got a 15-inch trunk that's blocking it, but the canopy's high in the tree. So it's not really blocking a lot. And so,
right.
So again, it's back to, I'm trying to accommodate everybody and listen to everybody's concerns. So it's tough, but we can, put 2 rows of Leyland cypress. I mean, it's just whatever we need to do. But again, we were trying to accommodate everybody.
Yeah, no, I understand. And personally, I mean, a 50-foot natural buffer in sort of what I might call sort of a scrub forest, it's not like old growth or anything. It actually doesn't provide a lot of protection, really, in my opinion. I just want to bring that up. I'll leave it up to Hutch. Hutch has kind of spoken with the neighbors over there. I haven't. I like the idea of the fence and the Leyland cypress. I think that's a good proposal. I think a more expansive solution back there would, if I were the homeowner, that would be my preference. But again, Hutch, I'll just defer to, that's just an idea. Then the other question I have has to do with the front and the 100 feet. What are the landscape plans there along Route 20? I didn't see anything indicated.
Again, I'll let Steve elaborate. Steve was actually in the landscaping business, so he can make it look really nice. And of course, if you all saw pictures of the store land over in Culpeper, it's very attractive, even up against the buildings with the plantings. But we're already required. VDOT's already got a wide right-of-way through there. It's just not 50 foot. It's almost 110 foot of right-of-way. And Route 20 is in the middle of that. So you've got 60 foot almost on the other side before you even get to our 100-foot setback for the building off of
Gotcha.
the right of way. So we're really tucked up into the woods almost because of the setback of the buildings. But so
Yeah.
there's plenty of room to do landscaping, and we want to make it look attractive. So, you know, we'll probably exceed any of our landscaping ordinances that we have for Orange County. It will be attractive. But Steve, if you want to elaborate on that, you know, it's fine too.
Well, we're planning on doing the ornamental fence all the way through the front on Route 20 just for the aesthetic value. And then we'll do larger trees than necessary. We won't put in like an 1.5-inch caliper tree. We'll put in like a 2.5-inch caliper tree. It responds more. And we'll be putting in like a double row of shrubs in most of it, just so that if you look at the pictures of Storeland and Culpeper along the building, you'll see where there's like a 2-layered level of shrubs. And that really helps stop the line of sight from the road, because the road will be lower than the facility. So when they're looking up, they won't be seeing much of a car or anything sitting there when they're just because of the angle from the road. So the shrubs will be up within a 4 or 5 year period. They'll be up probably 5 feet steady. You know, keep them at like 5 feet up along a 6-foot fence or 7-foot fence, depending on what we put up. So we're really, but it'll be aesthetic. You know, the contrast in colors. So it'll be something that you know, definitely want to make sure it's the nicest looking property on 20 when people come down the road. That's part of the marketing we like to do.
It might be the nicest looking place in that area. You never know. So just thank you for that answer, Mr. McLean, and thank you, Mr. Dotson as well. From my point of view, to the other commissioners, as far as conditions, personally, I would like to see, you know, what Mr. Dotson described in the back with the Leyland cypress and some sort of description. You heard my personal opinion, but you know, I'll defer to the rest of you all. I'd like to see that, you know, somehow delineated in a condition. And also, I like the description of what you're intending to do in the front. My opinion would also be to have some sort of condition that sort of lays out, and I don't know exactly how to do it, and I don't want to make it too complicated, but you know, maybe it's something we could agree to where we have a condition, you know, on landscaping in the front, and maybe that gets more developed before it gets to the supervisors. But in the front, I think a condition that has sort of at least a placeholder there that commits the landscaping. And again, I know you guys will do it. And but I will personally, I'd like to see a condition in there on that. And then again, some sort of condition for the back screening as well. That's all I have, Mr. Chairman.
Thank you, sir. Is there any other commissioner have any comments on anything?
Mr. Chairman, one comment and one question. Jim Hutchison, District 5. I concur with Mr. Capel on the conditions, but just to make you aware, Lake of the Woods requires a significant setback area on the property from the property line back to the dwellings. So there's additional setback areas that already exist, which can be cleared. That's not a problem, but they're there. The other question is, we had discussed at the last meeting the opening time. And it was explained about different contractors, et cetera. There were some comments submitted by some of the landowners to try and modify that opening time, if I remember correctly, from 4 or 4:30 to 6 o'clock a.m. in the morning. Can you comment on that?
Well, we initially talked about opening at 5, and in our on the October 9th report that I sent back to you, we were talking about doing 6 in the morning. So,
Great, that's all I need.
okay.
The concern that I have, to follow it up, is that when we look at what, I'm not picking on the Lake of the Woods and because they're HOA, is not where I'm going. But the reason I asked the question about you can't determine the property line it's a little bit unfair to look at that easement, if you will, or that area back there in the back and say, oh, these are down trees, these need to be fixed, and we don't really know whose property they're on. In fact, if they're on the HOA of the Lakewood Woods, then they're responsible to clean it up a little bit back there for those tenants back there. Well, I won't say tenants, those residents back there, and not necessarily the applicant. But if the applicant thinks it's best to clean it up back there to make it look better, I'm all in favor of that. A down tree that's rotting and making a poor habitat looking area, so it's not habitable for anything, it's not disturbing anything, we should just clean it up and let them go ahead and plant the Leland cypress to make it look better back there. It'd be better for everybody. And even when the lake comes to put their fence up, it'll be better for them to try to put a fence up. I kind of know why they don't have a fence up back there. It's pretty rugged. It's gonna cost some money to go back through there and do it. But the applicant is willing to go back and do it on his property. So I don't know, Sandra, I guess my question is more to you. Can they clean that off and put Leland cypress back there and do what they pretty much want to make it look better?
On their own property?
Yeah,
not
on their
speaking
own
about.
in the buffering area and the which they have explained. I think Mr. Dotson has done a phenomenal job of explaining what he would like to see back there. Mr. Capel kind of chimed in. Let's make it look better if we can. I would think that the residents would rather see Leland cypress growing pretty than fallen oak trees and pine trees, because the pines are horrible back through there, as they are everywhere.
Yeah, I mean, as long as what they are planning to do, and I believe it is, as long as it's consistent with the requirements in the zoning ordinance, at least the minimum requirements for maintaining a buffer there, then yeah, they can design it and however they want to. I mean, we have the authority, of course, to approve it, but yeah, I believe they can do what they want to do, as described this evening.
Okay, that makes good sense to me then. And then as far as the time goes, can we alter the time so if it, of their proposed time, so that it will appear in a motion one way or the other, so that the time would be altered to 6 o'clock in the morning? I think that's what everybody's proposing.
Right.
Okay. So, and then the only other question I have is, can we just have something in there that says they will have a minimum of 5 noise signs up, to include one at the front and one at the exit if it's 2 different places? If they come in and go out the same place, then they'll only need 1, but I want it facing both ways.
Okay.
Hey, Mr.
Any
Chairman?
commissioner got any problem with those? Mr. Capel, go ahead. I hear you.
So these would become conditions then, correct? So one condition is you're saying you'd like at least 5 of those noise signs.
Right.
As far as the buffer in the back, I mean the C2 ordinance has some language. It says suitably fenced and/or landscaped to screen agricultural or residential use. Maybe we could frame a condition that says, you know, an either or, either the 50-foot buffer is left as it is and a single row of Leyland cypress are planted. What did you say, Mr. Dotson, 10 feet on center?
Yeah, but again,
Yeah.
It would be the 30-foot natural buffer, but then in that 20-foot that's remaining, we would plant the Leland cypress at 10 foot out, if that makes sense, at 40 foot, right. So we would still be
But it would be
50
50-foot total,
That's
and you're planting a row of Leyland cypress in the 20 feet closest to the fence.
That's correct.
Your fence.
That's
Yeah.
correct.
Right.
So it could,
So that you
go ahead,
can
Mr.
maintain
Chairman.
it better. Just so that you can maintain it better, right, Kent?
That's correct.
It's
And the
for
thing
your
is,
maintenance.
right. Well, then we don't have to worry about those trees, those hardwood trees 20 foot back. They'll be in our Leland cypress, and then our fence would be there. So the Leland cypress are not on our side of the fence neither, but it's still on our property. We just, that way the fence is really what the pedestrians will get to.
Right.
Right.
So it's still a 50-foot buffer.
Mhm.
You're just proposing you put your fence at the 50-foot line, and then on the back side, on the back of that fence that you put up, a row of Leyland cypress that will take up approximately 20 feet,
That's correct.
leaving 30 feet either natural. And so I would frame it that the condition is to do that, plant the single row of Leyland cypress and leave the 30 feet of natural growth as it is, or clear the 50 feet total and put at least 2 rows of Leyland cypress. Would that be acceptable, Mr. Dotson, as far as a condition? Sorry, sir, you're muted.
I'm sorry. Well, I've got some dogs here ready to come in the door. So I'm fine with that. Steve, are you good with that?
Yeah, that should work out. If we're
Okay.
gonna have to clear that, it would make it look a lot better if we had to clear it.
Agreed.
So it would be an either or condition is what you're proposing, Mr. Capel? Just so
That's
I'm-
what I'm proposing.
Okay.
Either a single row of Leyland cypress within the 50-foot buffer and at least 30 feet left natural, or
Right.
a cleared 50-foot buffer with at least 2 rows of Leyland cypress.
Okay.
Which satisfies.
And then the-
C2.
I'm sorry, Mr. Hutchinson.
Yeah, that satisfies the C2 requirement.
And it also
Yeah, and-
satisfies the concerns of the adjoining property owners as
Exactly.
well.
Absolutely.
And then a condition in the front that I don't know how to quite describe the landscaping. I don't know the right language in there. I mean, I heard what you said, but some sort of condition for landscaping in the front that, and I don't know how we frame this, but some sort of,
exceed the current landscaping ordinance.
okay.
Yeah. And then,
Okay, that exceeds the current landscaping ordinance. And it would be nice to have some sort of little better plan available for the supervisors. That would be a good thing, I think, for them to see.
Okay.
A little better plan there that, by the time you get to I mean, I can't make you do it, but
right.
that's my opinion. It wouldn't be too hard to do a little sketch that kind of lays it
I
out.
think we'll attempt to do that for you. Okay. For them.
And then the time, Mr. Brooks, that's in their proposal now, or do we need to add that as a condition?
Well, I think they accepted that in their proposal because the applicant is the one that stated to 6 o'clock. Is that correct, Steve?
That's correct.
Okay, so we don't need to condition that, but if you want to put the condition there, it doesn't matter if it's in 2 places. Where would you like it, Sandra? You're the one got to, yes.
Well, the way the conditions were drafted, the first item is that controlling document shall be the conditions set forth and the document submitted with the application. So I think what they have submitted and then any additional information that they may provide for the supervisors would be considered the controlling document. So they have included in that an opening time of 6 a.m. and I think that would be sufficient. But as someone said, if you want to do sort of belts and suspenders, I guess it wouldn't hurt anything, but I don't think it's required.
All right, thank you. We'll just leave it at their application there and make it easier that way. Now, hearing all of that, we have to separate the two. You kind of got to go with the continuation of rezoning, and then some of the things we have will apply to the SUP, the conditioning and things like that. So don't you think it's best for clarity to either approve or deny the rezoning and then add the SUP of being able to put the storage shed there first?
Well, yes, I mean, the approval of the special use permit is contingent upon rezoning to C2. Yes, you would need to have a motion to recommend approval of the rezoning. And then that could be followed with a motion to recommend approval of the special use permit with the conditions. Because of course, the conditions that have been discussed will be applicable to the special use permit.
Okay, so the chair solicits a motion for the rezoning of 20-02. At this time, the motion can be for or against, however you want to do it. But let's do the number A first.
Mr. Chairman, point of order.
Yes.
And that is, I thought we were working on the public hearing for 5A, and we didn't open one for 5B.
That's why we're doing 5A now. And then we'll do 5B in just a second, but you can't really separate them but so much. But 5A is what I want a motion on, and then we'll go to 5B, and we can take by consensus the conversation we had and the different things we had with 5A to include 5B.
Chairman Brooks, I'm sorry to complicate it. So two things. First of all, I'm pretty sure we opened the public hearing on both 5A and 5B last time. And then you had to close them separately, which I think is kind of what you said. But in terms of the conditions, I would propose that the condition that provides the buffering to the residential, that be attached to the zoning, to the rezoning, because that puts that there no matter who shows up, right? So later on, if hopefully Mr. McLean is able to finish his project, but if for some reason he can't and someone else buys the property, that would ensure that screening is there regardless of what else goes in to protect those homes there.
So point well taken, Mr. Capel. I'll put it on you then to pass make the motion with that in there.
Mr. Chairman, if I may, and Eric may want to comment on this as well, that would require, I believe that would require a proffered condition that would be prepared before the board's public hearing. I don't believe, I mean, I believe that would need to be a proffered condition from the applicant to be considered a condition attached to the rezoning.
All right, hold on just before we go to Eric. It seems to me though, Jason, let's have a conversation between you and I and see if we could get some clarity here. Other commissioners can chime in if they so desire. Applicant, actually, just to hold your peace just for a second. If this is rezoned affirmative as A states, that's all it is. It becomes a blank piece of property that's been rezoned and they can't do anything with it for nothing other than a store land. When you go to B, then that's when the requirements come with the special use permit that is allowing it to function as a entity of storage, and it would go with it. So I think your point's well taken, but I don't believe it's as drastic as you may think it is, because they have nothing if we just give them A. That's why they got A and B here.
Well, if you give them A, they have by right any use allowed in C2. And there's a lot of uses there. And
but they have to come back and get a special use permit to do any of those uses in C2. That's why they got to get one now.
They have to get a special use permit for their storage use, but there's a whole bunch of other uses allowed by right. And all I'm trying to do is lock that screening in so that no matter what happens on that C2 property, the homes there have good screening.
Okay. Mr. Lansing, are you listening?
I am. I'm looking up this question that, can you hear me?
Yes.
Yeah, I can. Are you going to be the negotiator for us?
Yeah. What's that? I'm sorry.
I was just being a little bit funny. I said, you going to be the negotiator for us?
I wish. Um,
All right,
I'm gonna ask the chairman's leave to give Tom, the county attorney, a call on this and see what his take on this is. I feel that Sandra is likely right, but I want to be sure by giving him a call. Do you mind?
I don't, we would ask that we would just pass this over for, you think you can do it in 15 minutes?
I think so.
Okay. But waiting the attorney to do some legal research with the senior attorney. We'll pass this over for 15 minutes. Let's move down into our work session because I think we can clear this up in 15 minutes. And to the applicant, we ask your patience. Sometimes we need some legal advice. We want to make it right for you. In this work session here that we got 6A, this has pretty much become a bone of contention in some ways of how it's being presented. We had a lot of questions at our last meeting. I spoke with the county attorney. I spoke with Mr. Thornton also, and it seems as though there's an unwillingness, put some emphasis on, it seems as though there's an unwillingness of the applicant to understand the procedure that must go on in order for us to approve. And thus we ended up sending a letter to the applicant saying, listen, we understand you have an approval and you can stick with your approval that you have, but this is the guidelines that we're going to go forth with. And we need you to kind of fall into what we're trying to do. It didn't get very far. I guess what I'm saying is what we wanted them to do is that we would take the last meeting's conversation and last meeting communication and presentation and anything else you want to call it as a part of the pre-planning for their submittal as GWAP calls for. And we would take this one and continue, and then we would move it on to a time so designated probably in November for us to approve or deny. Any commissioners got any comments on this? Sandra, if you want to chime in and help me out here, it was greatly appreciated.
Mr. Chairman, I think that maybe one thing I would just acknowledge, for the commission and I guess for the public, and this was stated in the letter, the reason we are going through this work session process now is because I had overlooked that as one of the steps in the Germanna Wilderness Area rezoning process, and that did call for a work session just for discussion between the applicants and the commission prior to proceeding to public hearing. So I had overlooked that. As Mr. Brooks said, Chairman Brooks said, we did have some discussion of considering the October 1st meeting and also this evening's meeting as that work session item. I think one of the things that, from my perspective, makes this application different from perhaps a new application, a brand new application coming in, something that you hadn't seen before, is the fact that these, as you mentioned, Chairman Brooks, these
See, the commission is silent, awaiting the word from Tom. I just talked to him and he says Sandra is right. Can y'all hear me?
Yeah, hang on just a second, Eric, if you don't mind. Eric?
Oh, I apologize. I must have interrupted something. My sound was silent, and so I just rattled on.
Hang on just a second.
Okay.
Go ahead, Sam.
Where was I? I'm trying to remember just where I was. I think I was saying, I think that to me, there were a couple of, factors that caused this, application to be maybe different from a brand new application coming before you in the GWAP, is that they do have, as you pointed out, Chairman Brooks, an approval by which they could actually, just proceed. But I think they have found, and what they have expressed to us as far back as, I guess, November of 2018, is that the phasing, there was a proffered condition concerning the phasing of commercial versus residential development, and that was hampering their progress. In reviewing notes, and some of those notes are admittedly a little sketchy, I do believe that there may have been, certain things represented to them about what they would need to do sort of as a minimum submittal to go forward with the rezoning to the planned mixed use district. And as we know, there's always a lot of room for errors in interpretation on both sides. But I do think that the applicants had, based on comments that were made to them in November of 2018, they believed that they could go forward with their project based on the draft Corridor 3 standards, which included design and architectural standards and landscaping. It was represented that they could go forward with that. Now, I don't know for sure if, the intent of, that indication to them meant that they still needed to provide elevations based on those corridor standards. But they were told at a meeting in November of 2018 that that would be acceptable. There had been conversations with VDOT concerning what they would require as a minimum submittal for them to evaluate a new application. I did not find in my review of those notes any discussion of a reevaluation of the physical impact analysis or what may or may not be required from that standpoint. So just as a way of, I guess, some background and just filling in a little more information about, why we are where we are, I hope that will be at least somewhat helpful.
Okay, any commissioner got a question or comment?
Mr. Chairman, I have a comment, and not really a question.
Bill, go ahead.
So
Go ahead.
let me summarize my opinion of what's going on. So there was a plan that was approved under a different zoning ordinance, and now the applicant wants to do something different, which is fine. But basically what they presented was the old plan and the old information, and then they just kind of described what they think they might want to do in the future. And I really do not believe that that's surely not what I heard, in how we were going to conduct GWAP applications. So in my opinion, we don't have the information we need to make a decision on it. And it's really that simple. And I don't think that the kickoff of the GWAP, the first project out of the gate, ought to be, however many year-old plan and a verbal description of the changes that they think they're going to do. They've reduced the commercial. I mean, to me, it's just an incomplete application. And I'm sorry that the applicants, have been through whatever they've been through, but I don't feel like there's enough to approve or deny anything. It just looks like the old plan and some verbal changes.
Any other commissioner got a comment?
Yeah, Mr.
Go ahead,
Chairman,
Mr.
this is, I understand and appreciate Commissioner Capel's viewpoint. However, the facts are that in the meeting, our former county administrator verbally conveyed certain things that basically, to me, committed Orange County to facilitate this change and to move forward by telling them to specifically just incorporate the fact that it would be in compliance with the ordinances and requirements of the landscaping, signage, etc., under the GWAP. These folks, in good faith, proceeded on that basis. And now, because it has been discovered, they're being asked to rectify this beyond what was conveyed in that meeting in November. I personally don't think that's right. I think it's bad policy to do such. And from my perspective, I understand the need of conformity. I was a member of the GWAP advisory committee, and I appreciate that. However, from a legality standpoint, as my father always taught me, your word is your bond, and they got a specific indication from our former county administrator that's contrary to what we were asking for them to do at this point.
Any other commissioner?
I'd
Well,
like to ask, this is Jim Hutchison, I'd like to ask Eric for his opinion on the meeting that existed with the former planning director versus the fact that we have a published GWAP plan. From a process standpoint, I don't know whether or not the application for the zoning map amendments by a developer, whoever, has been published and available to anyone that wants to use it. But Eric, what do you think?
Well, as the meeting in November, I wasn't present at that. And I believe this is the same meeting that Sandra, there was an email thread regarding that Tom mentioned. He doesn't have much recollection of that meeting either. Is that right, Sandra?
Yeah, and based on my notes, Tom wasn't present for that particular meeting.
Okay. Well, I guess that would explain why he doesn't have any memory of it.
Yeah.
But as to the application, there's no record of the application ever having been ratified by the Planning Commission, by the board. And really there's no required process for an application having to be ratified by anyone. So really that's more of a, I'm not sure if point of order is the right phrase for it, but we have an application that hasn't been ratified. It doesn't have to be ratified. The application isn't something that establishes binding law or requirements. What we do have, which was, I think, in draft form, is something that, as Sandra and I believe the chairman had discussed about it, they arrived at a version of the application that they decided to proceed with, and that is procedurally fine for them to do exactly that. As to what weight the materials in the application are given, that's sort of an individual choice for the commissioners to make. Sandra, have I described that procedural background accurately?
I think so.
Okay.
Any other commissioner have a comment or concern? I've got a couple on this issue because I've been kind of in it all the way up to my head for a week or more. Mr. Yancey, you're correct on the way the process went and the way it appeared the intentions of the former county administrator wanted to do. And I hear that. But bad information is bad information, irregardless who you get it from. And the information they got from the county administrator, it was just flat wrong to do it that way. Now, should they suffer some consequences from it? My answer is simply no. But what they have to do is to comply with the rules of today. Everything typically has changed. Even now in this COVID times, you could walk up in a place. You can't now. You got to set appointments. Now, what do we do as a county to try to make things right? That's why I asked the county staff to write him a letter and outline exactly what we needed. Mr. Capel is right also, too, and it's kind of weeding between all the rights. Mr. Capel is right because they have not fulfilled their obligations. If they want to change what it was granted to them, they have to fulfill the current obligations to do it. I wanted the pre-planning work session, I wanted this session, and I wanted them just to update some information. I'm talking not for the county. Just update some of the information that they had in there so it's current, we could use current data. At the present time, we all know, and I'm gonna step out on a limb here and say we all know how the previous county administrator left here. We know what those terms were, or you probably heard. Therein lies the problem that we have. When somebody is leading county government and not doing it the way that it should be done, or the way we would expect it to be done, these problems are created. Do we follow that trail though, or do we try to get on a better trail is my question. So with saying that, I say this, let's get on a better trail. And I've sent them an olive branch of a letter. Hey guys, help us play with you. Let us try to help in making this better for you. There was nothing that we required of them, nor are we required to grant them what they want based on bad information. We're just not required to do that. But nothing we require of them is really that onus that I see, unless some commissioner can tell me, what are we asking of them that's really going to give them a real big setback? Somebody please tell me.
My response to that, Mr. Chairman, is a question for Mr. Lansing. Because of this development, from a technical timeline standpoint, if we require the applicants to go back and do a updated impact study and the landscaping, et cetera, it's, in my personal opinion, you will not be able from a timeline to stay in compliance with the tracking of this application on a basis of us elevating it up to the next level to the Board of Supervisors in a legal manner, correct or incorrect?
In other words, we can't just punt the application for but so long before it's considered automatically recommended, right?
That's correct.
Yeah, that's correct. Now, I'll add one, well, sort of two qualifications to that. The continuity of government ordinance suspends deadlines, so that would that sort of could get us out of that deadline. We'd have to justify how it's related to COVID, which I don't think we could do. The continuity of government ordinance does end, it expires by operation of law at the end of this month, unless it is renewed by the Board of Supervisors, which I don't know whether it will be. But I think the simple answer to your question, George, is yeah, that we're limited in our time frame. There's some loopholes I could find in that, but the simple answer is yeah.
And that's not the applicant's fault.
That's right.
And if I may bring up a point, I asked this question long before this document showed up. It was the first thing I asked about. And so I really, I don't understand what's wrong with asking an applicant to provide their plan. I really don't. That doesn't seem unreasonable to me. And I get all the time frames and I get all that. And so, you know, my position is I can't approve what I can't see. And, you know, so that, you know, that's just my opinion. And I would encourage the applicant. I mean, this is going to go to the supervisors. I mean, I can't imagine the supervisors approving something that they're not even willing to put on paper. So, I mean, we're looking at a drawing that shows a large area of commercial, and that's not what they're going to do. And the economic studies built on a square footage of commercial that's not going to exist. And what they're basically asking for is, hey, I want to build my residential, and gosh, I hope the commercial shows up someday. I'll try my best. And I don't think that's, honestly, Mr. Yancey and Mr. Hutchinson, that couldn't have been your vision for the GWAP. And I understand this is an unusual situation, but you know, I just can't see that this being our first project in the GWAP. I think that doesn't do service or justice to the amount of time that you all put into that effort.
You know,
and I'll leave it there.
Two wrongs don't make a right. And where I kind of agree with Mr. Yancey and Mr. Capel, I'm also concerned about setting a precedent for the GWAP area. And I think part of it's our fault. We've got a transition of a application that's changed from one that was non-GWAP to a GWAP multi-use initiative. And my opinion is that we need to do this right, and we need the information to do it correct. And I think the supervisors need that information to do it correct, even though it's going to probably cause a delay to the applicant.
Okay,
go ahead, Mr. Yancey. I'm sorry. Go ahead, Mr. Yancey.
My question ultimately is this: from a legal standpoint, what is the resolution to resolve that is both fair and equitable to Orange County and to the applicant?
Well, we're speaking legal, Mr. Yancey, because there's a supposition that somebody might sue us. That's the only way legal it would come into it. We've got a set of standards and guidelines that GWAP worked out, and we should follow them. I guess where I'm at, I'll go a little deeper into where I personally am. Why would you want to start such a venture and have 14-year-old information? Why would you want to put millions of dollars in something that your own information is dated? I mean, I wouldn't want to do anything that they were doing 14 years ago. I get what they're saying. They can move dirt and build a house, but have they looked at the housing market for the area? Have they looked at what's the buying resolution for the area? I don't want to stop them at all. That is not my intent. But my intent is to do it right. Mr. Hutchinson said something that was correct, in my opinion. Two wrongs don't make a right. We have acknowledged that the previous information they got from the county was probably not correct. Should we follow the not correct information, or should we try to do it right? I think we're more legally tackled if we just start setting precedents in GWAP, and then the next person comes along and says, I want it too. Then what do we do? But if you do it right from the beginning, you know, Harper's crown in the box, but my grandfather was a contractor, and he used to say this. He said to me, he'd say, grandson, if you don't start off square, you're going to chase that throughout the whole house. If you don't start square, you're going to chase it through the whole house. And sometimes we get there and something wouldn't fit. He said, we didn't do something right. Now we got to cut something and do something and patch something. So if we don't start square, folks, we're gonna chase it through the whole GWAP. Let's start square and not chase, is my opinion. Comments?
I agree with that. I still think that, and other counties have held them, is that this GWAP effort moving along, and we've gone into shock mode with this first one, which to me was a surprise because of the change, that we need to do a town hall meeting for the community so they understand what's going on with GWAP.
True, true. Point
Hey,
well taken.
Mr. Chairman, can I make a suggestion?
Yes, sir.
So
Yes,
I'm
sir.
curious, in fairness to the applicants and Mr. Lansing, the timeline, can we lay out, when do we need to decide on this is what I would like to know. And can the applicants provide us some level of information, more than we currently have, that would allow us to kind of at least get to some sort of decision, right, wrong, or indifferent, and get this. I mean, I assume they want to move it up to the supervisors. So what's our timeline? When do we have to make a decision before this falls off our plate? And then the next question, what information are the applicants willing to provide before then?
Mr. Capel, that's just the question I was trying to find in the state code, what the timeline is, and my recollection is 45 days. But Sandra, I wonder if you recall what is our timeline for the processing of this application?
I'm looking at that right now too. I mean, we've got
Well, I think one thing while y'all are looking, we got to figure out what's the time that has started. If we've gone back to the pre-application stages to have the conference, when do we date the reception, the receipt of the application? On the GWAP, I guess is a better thing, because GWAP puts some things in there that the typical application doesn't put in.
Correct. Let's see.
Mr. Chairman, I don't want to belabor this, but my point
Go ahead.
is, I believe we put the applicant in a position that there's no way they can be legally in compliance with what we're requesting. And I'm not saying it's an error. I'm just saying, due to circumstances beyond their control and based on verbal communication from county representatives, they're at that position now. So, I understand we want to get off on the right foot with GWAP, but I also understand that the expense of doing what we want, and I understand why, is going to be fairly significant, and the time element is going to be greater than 45 days, in my personal opinion, and therefore that puts them out in left field without the opportunity to do anything at this junction. And I'm not sure I articulated that properly, but at the same time, what some of you do not know, this is the second time a representative of the county has misrepresented something to the applicant. It happened in 2013 because I personally observed it. And when I was not a commissioner at attendance of a meeting. So that's my final comment.
Sandra, the date I have for the application is June 26th, which puts
Yeah.
us well
Yeah.
past.
We received it in June. We have, once it goes through the, well, we had the 45 days for the review by other agencies, or application review committee. And so after that, we did put it on the first available agenda. Eric, I think, has been looking at the code. I had been looking to see whether we specified those deadlines in our ordinance, and we do not specify that in our ordinance. So as far as, I mean, I think we did use the allowable time for the application review committee review. But as I said, I don't, even though it has been in progress for a while, I don't think we actually went afoul of that requirement.
Mr. Chairman, I'm going to invoke the call a friend option again and call Tom if you would give me the time.
Okay. Okay, that's fine. While we're in the middle of this, I would say, Mr. Yancey, just a quick question. I hear and see your passion. I understand your dilemma. And doggone it, if county government could do better, we wouldn't be. I'll give you that. But we just play my game with me for a second. So we just go, okay, applicants, you are denied, or okay, applicants, you are approved. Just like it is. It gets to the board, and the obvious board members who are equally to our intelligence and astute ability, they go, we don't have enough. You are denied. What did we gain the applicant then? Because ultimately they want to be approved. So if we push through wrong and the board sees what we see, then what do they get? What does the applicant get then? They're really, really harmed now, because now they've been shut down the project completely, pretty much. What do they get? And my concern is, if we push it, the board will be right where they are, one way or the other. It's just because we deny it doesn't stop their right to the board, because we approve it. Doesn't grant them permission by the board. So, but the board's got their due diligence to look at it. And I just don't, I have not heard the concern from a supervisor. Typically, the concern that I've heard from supervisors is the dilemma we're in. Somebody kind of set us up, is what one of them said. I said, well, I don't particularly like that. I mean, this is, I think we need to do it right and then move on. I think it's 6 months that we have to do something, or it dies, but they y'all, I don't know. I hear so many times. But let's put this to rest for a second until Eric comes back again. And let's move along.
I've got the answer. Yeah.
Okay.
The timeline is 100 days. This is Virginia Code Section 15.2.2285, failure of the commission to report 100 days after the first meeting of the commission. So not when the application was submitted. So after the first meeting of the commission, after the proposed amendment or reenactment has been referred to the commission, or such shorter period as may be prescribed by the governing body, shall be deemed
100 days out from the first time we heard from them.
That's
would
right.
be what day?
The first meeting would have been October 1st.
It was what? October 1st, correct?
Yes, sir.
Okay, so we're 100 days from October 1st. Where would that put us?
We wish you a happy new year.
So that we got until the first of the year to get this done. So let's get on it expeditiously. Let's get it done expeditiously. We know what we got to do. So here's what I'm going to say. I'm going to expedite it as fast as I think we possibly can. If we put this on our first meeting in November, which I think is the 5th, correct?
Yes, sir. Yes, that's correct.
That's rapid enough for all commissioners and to get this wrapped up for the applicants. So virtually we're putting it on 16 days, right? 17 days, whatever the day is.
And Mr. Chairman, I mean, so what are we saying? That we're not going to request any additional information, and on 5 November, we make a decision based on what we have now?
No, that's not what I'm saying. What we're saying is that their application has to meet the GWAP standards, and that's what we're working under, the GWAP standards.
Mr. Chairman,
I don't know any other things we can work on.
one suggestion is that given the situation that we're faced with, it might not be a bad idea to make sure that we're on the same sheet of music with the county administrator and the president of the board.
You mean a chairman of the board of supervisors?
Yeah. Yes.
And what are we're supposed to be checking with them for? I'm lost.
No, what I'm saying is that our procedure to go ahead because of the situation we're in might be useful to make sure that both the county administrator and the chairman of the board understand where we're headed. By one, we know there were errors in the past, and number two, we want to do this thing right for the first GWAP application.
You can rest assured they already
cost this applicant time and money.
Well, and I think the applicant can get in there in good faith and clarify a lot of things for us. But here's one caveat I did want to put there. If the applicant deems that that's not enough time, they can ask us not to have it on that day. We don't care if they kick the can down the road. We're just not going to kick it no further down the road unless they want it kicked. Does that make sense to everybody? If they think they need 30 days, this is too soon, I don't have a problem with changing the agenda for them. But I don't want them to think that we're hindering them, because I think Mr. Yancey brings a good point. We shouldn't hold him up any longer.
You're going to notify him in writing?
Yes, sir. Mr. Lansing and Mrs. Thornton can tell you that's my favorite thing to do, write a letter.
May I make a suggestion, gentlemen?
Yes.
Ooh.
This is Bob Dudley with Signature Series. You haven't let us talk at all tonight. I've listened to everything. Well, I thought we were included in that. I'm sorry. Yes, sir.
Mr. Dudley. Mr. Dudley.
Yes, sir.
I know we haven't let you talk. Yeah, I know we haven't let you talk. This is our work session. It's not our public hearing. We will let you talk at some present time, but just hang tight. Just hang tight. We're trying to work these things out. But this is our work session. So this is not a session that.
I'm sorry. I thought we were included. I apologize.
You're included to be here, but I'll ask you in just a second. Here, just a second. Just chill. I'm gonna let you get into that. Now, based on that, you said we want to put this in writing to them, even though they're hearing it, Mr. Hutchinson?
Mm-hmm.
Okay, I don't have a problem with that. Mr. Lansing, are we going to be able to, I had a note here. Somebody threw me off here for a second. Oh, well, we're going to be able to, looks like we're going to be able to fill the confines of the law using that 100-day rule.
Yes, we'll be fine as long as we're within 100 days of October 1.
Okay. Now, the question I have is, does the commission have any problem with the applicant stating and making some comments on our work session issues? If anybody has an opposition to it, let me know. If you don't, I'm going to give them 10 minutes to respond.
Hey, Mr. Chairman, I don't have an issue with it at all. I just want to point out we've sent a letter, and the letter says what would be required. And I'd like to hear, I'd like to hear from the applicants, you know, whether they plan on providing the information and if so, when, and we could, you know, perhaps move our meetings around so they could provide the information. And if they're not planning on providing the information, why?
Okay, that's a good starting point. Mr. Dudley, state your name, your address, and your affiliation, and Mr. Capel kind of open the segue for us.
I'll start for Bob. This is John Marcantoni with Signature Series Development. I think we need to have a little more clarification and step back a moment. As Sandra had indicated, this is an approved project going forward. This all started back in February of 2018. We met with a couple board members, Jim Crozier and Jim White, who are still current, who essentially started as a amendment change to our proffer. We're not essentially changing our project except for bringing it a tiny bit into compliance, which basically taking our residential portion and making them VDOT roads. Everything else is essentially the same, but I'll get back to that. So we met back in February and July of 2018 with the board members discussing the path forward in which we were to follow. And that turned into the meetings with Brian David back in September 13th and as well as November with Brian David, the county attorney, Thomas Flysong, and as well as Sandra, which we essentially went down through the development requirements for the GWAP, which are the 7 items that essentially are in the adopted plan, which, you know, we went through each one basically saying, you know, our intent was never to come back for a rezoning. Our intent was basically to get a amendment change to our proffer so we can get back to work and make our development happen. So the evolution of this essentially came down to us coming into making this GWAP compliant, which we were already basically 90% GWAP compliant. And this went through the board. This went through Thomas Lashani, and basically said this shouldn't be should be more of a procedural rezoning where we can use all your old documents going forward, except for the only thing they could say that we couldn't do was the VDOT issues. And essentially, that's where we led to our meetings. So we met after those September and November meetings of September 18. We went on December 20th, met with a whole staff of VDOT, Marshall Barron, and multiple folks about which way forward to accomplish the VDOT requirements, which we did. We wouldn't come back to a rezoning and submit 10-year-old plans if this agreement wasn't in place. That makes us look unprepared, unprofessional, and not really a good partner, and that was not our intent completely. Our whole intent here was to move our project forward, which was this phasing requirement. It was the one thing that had to be changed for us to really move forward. And as far as Mr. Capel's comment, as far as us just wanting to build residential and go away, that's completely false. We've been in this project for over 20 years. Every year we spend over $20,000 on commercial real estate taxes. So we have to get commercial in there. There's really no other reason why we're doing this. This is just to go put residential in and think we're not going to get anything else. I mean, this is something we've been working for a very long time. And we worked on agreements that Mr. David provided. Sandra was in those meetings as well. You know, the letter that you provided essentially agrees with what we are saying. You know, the fiscal studies and some of the other signage plans, that was all basically to be in conformance with the adopted plans. And, you know, this was supposed to be a win for the GWAP going forward. And one point is we are already a part of the GWAP. I mean, we are already a GWAP project. So we're not setting any precedents. We're just essentially getting back to work and removing this one phasing requirement. And as far as changing the project, we were told not to show the large commercial big box because that's what was asked of us. And we added additional uses in because of what the county asked for. And in some of those meetings, the Orange Chamber was involved. And that's why there was a hotel use. That was why there was some other uses that weren't originally shown. The fiscal analysis is essentially hasn't changed for what our original project was. And essentially that's the same going forward. So, you know, Mr. Yancey is absolutely correct in the fact that we were provided agreements moving forward. Sandra would not have moved this project to your board if that agreement wasn't in place, because they're right. All these plans that we provided are 10 years old. I mean, we wouldn't do that if we didn't have those prior agreements in place. Unfortunately, that wasn't clarified to you all, unfortunately, which is leading to a lot of miscommunication and not understanding of how this evolved. And that's really it. There's really not much else beyond that. And Bob, if you want to chime in.
Bob Dudley, Signature
Okay.
Series. Mr. Brooks, honestly, I'm a little bit disappointed with you. You met with me in my office, and we went over these exact same things in the office. You and I talked about what we were about to apply for, what we were doing, and what we were told. And now you don't remember those.
Mr. Dudley, I never
Yes,
said
sir.
I did not remember. I never said I did not remember having a meeting with you.
Well,
I never
you
mentioned
didn't
whether I
know-
did or did not have a meeting with you.
I
So,
understand,
hold on
but
a
you
second.
didn't.
Hold on
You
a second.
didn't say anything about
Hold on one
you
second.
didn't. Go ahead, sir.
Hold on just 1 second. Hold on 1 second.
Yes, sir.
But I also remember saying to you, it was a very rainy morning when I met with you. And I remember meeting with both of you all, and I said to you all, if the county has agreed to do something, then we're ready to go forward with what the county has agreed. When
Yes, sir.
when it was looked at, the agreement was verbal, but it was never written. That's what you said to me, that you met with the county administrator and the planning director, and it all was okay. I said, if that's the way it is, dudes, it's no use meeting with me. That's the way it's going to be, because your plan is in place. And that's exactly what I said then, and that's what I say now.
Yes, sir.
But the problem
That's what you
is-
said, but then you changed and
Hold
said,
on.
because Sandra described exactly what we said with the agreement with Mr. David. And then you all of a sudden we got to go by what the
But
original
between
GWAP
now and then also, hold on a second. Between now and then also, if you check your timeline and your dates, GWAP changed and GWAP was approved. There's GWAP requirements that were put in there since that conversation and since that time. Go back and check your dates. And what
I
I'm always
understand,
going to
sir.
stick with is that what I'm always going to stick with, so you can understand this, is that we have to follow the guidelines that's put in place. Had I known GWAP was going to be something, we even ourselves didn't catch that it hadn't gone through the GWAP procedure. The Planning Commission didn't until Mr. Yancey brings it forward. So let's get it straight. I don't have a problem with your project. I'll go on record saying I don't have a problem with your project. I don't have a problem if they will allow you to take those proffers out. I don't have a particular problem with that. I have a problem if we don't go forward as the rules are prescribed for a project as are today. It's the same thing I said to the previous applicant tonight on the storage things. Let's do it the days route. I don't have a problem with your project. So you get that in straight quick. I don't have a problem if you building it, but we have rules to go by. And if we don't go by the rules, it doesn't matter who. Now,
Mr. Brooks,
I'll say to Sandra, I'll say to you.
Bob, let me, Mr. Brooks.
Go ahead.
In all fairness, we did use the development standards that are the same that are adopted now. That is how we developed the rezoning submittal. And that was what was allowed. The county waived those requirements going forward, except for the VDOT requirements, which when we took care of the rest of the requirements, we proffered that our project would meet all GWAP regulations. And that was why that proffer changed to meet those standards. That was the whole point of that. And as far as you know, VDOT, we were able to work that out and use our old plan because really the traffic hasn't changed in 10 years there, to be honest with you, based on VDOT's view and ours. And we had to update there was one chart we had to update to provide the VDOT, but also make our residential meet VDOT requirements. And that was part of that plan is what's changed. Other than that, our plan meets GWAP regulations. So I take offense that we aren't providing what's required.
John,
yes,
let's
sir.
flip the script just a second. You and Bob both. Since you want to call out, let's flip the script. You become a commissioner and I become an applicant, and the T's aren't crossed and the I's aren't dotted as they should be. Let me finish what I'm saying before you get on it. Would you want to accept as a plan where the demographics are showing bad population, school enrollment, 13 and 14 years old, and as a commissioner, not as an applicant, but as a commissioner, would you want to accept that and say, I approve this plan as that such?
I would accept that as a commissioner, that the county, i.e. the planning commission, our planning director, or Sandra, would provide that information that was the deal going forward. And with that deal in place, like you said, this is a special rezoning in the fact that you're changing a phasing requirement on a property. That is it. There's nothing really else changed except for bringing that VDOT up to date because the subdivision ordinance changed for our townhome communities that required VDOT roads. Otherwise, the project is essentially the same, and we just did not show the big box there. And Mr. Capel, we still plan, if we can build 237,000 square feet of commercial, that is our intent. But, you know, in the current market, hopefully we can get there. If not, you know, we are going to make every attempt to fill that commercial out. It behooves us to. And we wouldn't have got to this point without having updated plans if that agreement wasn't in place. And, you know, we would be remiss if we submitted that without those agreements in place because we'd be idiots for doing such.
So I hear what you're saying, but you didn't ever answer my question. As a commissioner, do you feel you should do it the right way or do it this way? That's the only question I'm really asking.
Well, I would say there's preconditions involved with that. It's not just a simple yes or no. This is an approved project, as Sandra had indicated, and this is more of a procedural change to a property, not necessarily a full rezoning package that we're changing anything. Essentially, we're adding the improvement of the VDOT roadways internally to meet that last bit of GWAP. Other than that, we meet the GWAP, and we are part of the GWAP. So as far as trying to set precedents, we're not, because we're already in the plan. Sub 1A Spotswood, look it up. I mean, Signature Station is there, front and center. And that's why we went to the county initially, talked to Mr. Crozier and Mr. White about a possible just procedure change, but they wanted to be able to have a win for the county saying that the GWAP is alive and moving forward. That's it.
Hey, Mr. Chairman.
Any other commissioner have any comment? Yes.
Yeah, Mr. Dudley and Mr. Marcantoni. Listen, I mean, I don't know about, and you'll hear me gripe about this on every meeting. I don't know about all the little things that went on behind the scenes. This is the first I've heard of any of it. Okay, all I know is so here's my perception, just so you know, right? I don't know you guys, I've never met you. You seem like fine fellows, right? All I know is last week, this thing shows up and it's 10 years old or more. And you're describing to me some changes you want to make. And all I'm asking you to do is put it on paper. And I don't feel like that's unreasonable. And I'm sorry for all the stuff that's gone on in the past. I mean, it's unfortunate. And you heard me at the last meeting talk about some issues related to that. So, you know, from my perspective, and I'm not trying to be mean about it, from my perspective is you're giving me some verbal platitudes that I don't have anything in writing. And I'm a review plan guy, you know, like I've reviewed plans for most of my career. So I'm used to seeing things like that. And then the last thing I'll say is, I'm not so sure, I'm going through the proffers here that were agreed to before. I mean, it seems like there's a lot of proffers in here that aren't showing up in the new proposal. So listen, all I'm asking for is like, show me what you're proposing. That's all I've asked for. So,
Mr. Capello, we're not really proposing anything different. And that was the whole point of our rezoning. Like, we had never intended to come back to this point. And this was our biggest fear because, unfortunately, no disrespect to Sandra, the county didn't uphold their part of this process going forward. And that's where we're at. And unfortunately, that wasn't broadcast and communicated to the board about how that happened. And I wish Mr. Crozier was on tonight because he was in those talks initially and we all discussed this going forward. I mean, this is really led us down a path of that this should be not a big deal as far as getting a procedural change on a proffer to remove a proffer. And essentially, the other proffers that you're referring to were really handled in the one that we were going to do whatever VDOT requires, whatever our current TIA statement, which is the older one. Any of those improvements are we're still responsible for, and the other issues were more of stuff the GWAP the GWAP covered as far as buffer, landscaping, and those type of things. That was how it was conveyed to us to move forward, and now we're hitting this confusion of why we submitted this project with all this old data. That's exactly was our concern. And this is where we're at now because, now we have an administrator who's not the same guy who, he pushed this forward with us. And this is a 2-year process that we went through different agencies and different consultants to get to where we all agreed would be the right place to go forward. And we use the development standards that are adopted and are still adopted. So, as far as giving you new studies, unfortunately, the timeline, 100 days is one thing, but, we've been doing this for the last 2 years and the county's put the onus back on something we didn't agree to up front. And that's just wrong. And we're getting put in another position. And as Mr. Yancey said, this is the second time that the county has not stood up to their agreements. Unfortunately, I'm not a lawyer. I wish I was because I would have had this in writing. I've been a resident in the county for 17 years, and we've been good residents. We've been paying our taxes, and we're asking the county to give us some help. We worked it with your original approval, with trying to market it as such, and we weren't able to make it work. We needed to make this change so we can make it work. We want to see a thriving commercial and residential area that we think that we're going to be proud of, and we hope the county will be proud of. I mean, for saying there's nothing on paper, we provided that the last time. We were told, take that big box out and just show a bunch of uses that could happen there, and we're okay, that's fine. It's because as long as we meet the GWAP guidelines that were in place, it would meet the architectural, the landscaping, the signage, and any roadway issues that were out there. And, shame on us for not getting in writing, unfortunately. But the county attorney was well aware of this, and as well as a couple of the board members, and as well as Brian David. And if we have to search him to get him to give us a statement, I hope we don't have to do that. But this is just really unfair because, and I understand your position because I think your position is correct because you were informed by the county about how this progressed. We've been working for this 2 years, and none of this was broadcast to anybody, except for Sandra's letter that just came the other day, and that actually confirms exactly what we were saying, except for some of the one updated plan. Otherwise, this plan would have never came to your attention until all those plans were provided, and that's where we're at.
So, John, hold on, Jason, just a second. I got two questions. Where would you be if you had to work with the plan that's already been presented and approved? Where would you be?
Can you repeat
Where
that,
would you be
Mr.
if you
Brooks?
go back to the
You're
original
really
plan?
broken up.
It couldn't work, could it? I'm sorry. Your original plan that you have approval on will not work for you, correct?
Well, not necessarily. We didn't proffer that large development, big box envelope that we showed in our first approval, which is what we have approved at the moment. It's still basically a blank canvas that we have up to 237 square feet of 237,000 square feet of approvable space to build out. The big issue was this phasing. That is it. Other than that, the plan is essentially the same as the approval that we've had before, except for the updated VDOT requirements. And we're asking the county for help to help us get our project moving. And that's really where we're requesting that help, and that's where we're at.
Well, John, you and Mr. Dudley both have made a very compelling case to the wrongs. You really have made a good, compelling case to that. You've spoken to that very diligently, and it's been articulated to us. But what I have not heard is any concession to say, okay, we'll look at and try to help you off with some new things to make it easier for the commission to go forward. I have not heard your commitment, to this commission to even take a look at what's been presented and alter it a little bit, or see if you can enhance it a little bit.
I think $10,000 worth of VDOT changes is quite a bit.
Well, I'm talking about the plan that's submitted now, that's on the table. I'm not talking about what you did prior to the meeting on October the 1st. I'm talking the October the 1st meeting and what we have asked for and what we discussed tonight. What I'm personally looking to hear is you've told us everything we've done wrong as a county. And you've admitted you should have got this in writing. But what I'm looking for, okay, there's a happy medium, let's hope, or there's a movement on both sides, let's hope, to be able to convey this so it can work forward for you, so that we can be helpful to you. And I haven't heard that. I've heard we've done, we're not doing anymore. That's kind of what I'm getting from you. And that's all I'm asking. Have you done all you're going to do? You're not going to do anymore? Just say that if that's what you're going to do.
No, Mr. Brooks, that's not what we're saying. I guess we want a little more confirmation that the county agreed to what they agreed to. But it sounds like the only thing you're really looking for is an updated fiscal analysis. Is that correct?
Well, that would help. I think it would even help you.
Well, I'm not saying that isn't the case. I mean, that just wasn't one of the parameters that were provided to us moving forward. And that kind of puts us in a pinch. Even 100 days, that could create other issues going down the road. I mean, we have an approved project, as you had all indicated, but it's not the facet of submitting new plans for you to review to approve this, because it's approved. It's a proper change, and that is one administrative change that we're looking to be made. Other than that, we've worked with the county, bent over backwards for the county, and I kind of take issue with that, because we've done everything we can to push this forward, between working with the board members and the planning members, both past and present, to get to that point where you were able to review it. Unfortunately, that just wasn't clarified.
Hey, John, that's been well stated. Any other commissioner got anything else to say?
Can I ask a question before you go there?
Yes, you can. Is that Mr. Dudley?
Yes, it is.
Yes, go ahead.
I kind of like to ask a question to Sandra, if I could. I'm sorry.
That's fine. That's
Sandra
fine.
of the. Let me get rid of this other phone ringing in your ear.
Please.
Hey, Mr. Brooks.
Yes.
Chairman Brooks. I mean,
yes.
Are they saying that their original plan included condominiums and apartments?
That was asked. The county actually asked us to include that.
That's what I'm saying. Like, you know, I'm not arguing whether they asked for it or I'm not getting into that. But like, you're telling me that it's basically the same except for the phasing, and I'm like, well, wait a minute. What about the condominiums?
We'd be glad to take them out if you'd let us.
Well, Mr. Dudley, I don't know what you're proposing, completely. So it's, from my perspective, I'm just asking for, the fiscal analysis. I mean, I'll be honest with you. I mean, you heard what I said about the fiscal analysis before. I mean, they're going to make it, look good in your favor, and that's fine. I have my own opinion on residential.
Yes, sir. But, we understand.
Yes, but I mean, I'd like to just see, an updated plan. I mean, for me, it's just sort of the basics of what you're proposing. And I don't like, as you know, I mean, just proposing things verbally doesn't really work out real well. And
we can't design a commercial plan to what we don't know is going to be there. That's the reason why the GWAP plan was made so flexible. And I think Mr. Hutchinson and Mr. Yancey could explain that. The other part of where I was getting ready to go with this was, I wanted to ask Sandra a couple of questions real quick. And they were, Miss Sandra, in your letter, you had discussed the fact that 1 through 3 of your letter were discussed and cleared up with you with Mr. Marcantoni after the original meeting.
Well, I mean, it wasn't, I'm not sure I would characterize it as being cleared up. I had not understood until that conversation that we had that your reference to developing in accordance with the requirements of the GWAP meant that you were planning to rely on those draft corridor standards to address those items.
Could you explain those to the Planning Commission, what those items are, so that they understand that we weren't just ditzing our design, we were actually trying to comply to what they were asking for in those?
In the corridor standards?
Yes, ma'am.
There's information about architectural styles, building materials and colors, landscaping. I believe signage was addressed as well.
Yes, and those were also the questions they had. Correct?
But I'm sorry?
They were also the questions that they gave us, correct?
Well, it was related, as I
ma'am.
think we discussed on the phone, the ordinance and the application checklist specifies that those 3 things are required to be submitted with the application. And I had not understood until our conversation on October 5th that you were relying on the draft Route 3 corridor standards that you thought had been adopted.
Yes, ma'am. And that's what we agreed with Mr. David in the beginning, that we would not specify or design anything because you already had something adopted. We thought was adopted, excuse me,
right,
at that time. And so we based our design, we based the signs, and we based landscaping on that. So that part answers that. So the only parts of the questions after that was the physical study.
And some questions about the traffic impact analysis.
Right, and traffic impact analysis was answered by Mr. Marshall, who said we satisfied him at this point until we go further, and based on the amount of commercial, he would want more design.
More analysis.
Correct?
Analysis, yeah.
So we answered all of those. So for everybody to say we've done nothing, we did a lot.
Thank you, sir. Jason, go ahead. If you have anything, we'll move on.
No, I don't have anything else.
Okay. Mr. Yancey, you have anything else?
No, sir.
Ms. Lawmaker, you have anything else? Julie, you still there with us?
He's muted.
Mr. Hudson, you have anything else?
Well, I still have a lot of questions. I mean, I look back on this and the phasing is a major issue because the original requirement, if I'm correct, required 25% commercial before you could build rooftops for residential, which hadn't worked out over, I don't know how many years. So the next obvious step was go to a multi-use community, which lifted those restrictions, and you inserted the proffers. But just a point on the fiscal study. When you look at community cost impacts, and it talks about the county costs, the education in particular, these are 2008 statistics. And the impact on our schools, particularly tax-based issues, has significantly changed. So, you know, I have no feel right now when we take a look at it's 0.099 for elementary, 0.034 for middle school, 0.048 for high school, for a total of 0.181, which I think is terribly low, given the fact you're going to go into what I would consider low-cost housing, which means families. So I think you're looking at significantly more impact on our school system. That's just one example of what I'm trying to look at, so that we can make.
May I talk to that one moment?
No, hang on, John. Let Mr. Hutchinson finish talking. I'll call you out.
I'm sorry.
Anyway, that's one of the things I look at. Additionally, I mean, we've taken a look at the internal road networks and stuff, and I think if I'm correct, also we've gotten comments on the size of the cul-de-sacs and the roads for turnaround of buses that I guess based on the plan that you submitted is not consistent with what they require because they're not wide enough for our buses to make turns. So that stuff's not in the plans, and God knows what else. So
he's looking at all the old information, not the VDOT roads.
Yeah, the new plans show 60-foot roadways, sir. But if I may comment to the school issue, you know, these plans are based on historical data for what a townhome would generate.
Yeah,
and
12 years ago.
I worked on the Somerset Farm development. I developed that from the beginning. That had originally 320 units of single family, which ended up at the end of 260 units. Now, those are single families, and that obviously would generate a lot more kids than townhouses. So in the 17 years I lived in that subdivision, there were no more than 50 kids that generated through that time frame. So 40, I believe, is a pretty accurate number based on what they're calling for. And he's using historical data there. Yes, I agree. It's been 8 years ago, but the demographics haven't really changed very much in that area.
That's 12 years ago.
7 from the last approval.
It says in here 2008 census data.
I don't know which date. I know
page 27 on your page 27 on your cost to the community for the physical thing. But you know, whatever.
Either way, it was updated in 2013, but that's getting in the weeds. But I just want to make that point, and you know, check the data for Somerset Farms. How many children are generated there? There was one bus for elementary and middle school, and one bus for high school that really wasn't a full bus. And I know that from experience because my kids were on those buses. So I take exception to that. And, you know, I know there is a little contrary belief that the fiscal analysis doesn't really reflect the impacts of what the residential is. But our analysis has been pretty darn correct throughout, but just based on what Walmart provided.
Mr. Marcantoni, we're going to cut this off. This could go on all night long if we don't bring it to a halt here. This is our work session, and I don't mean to cut you off, but some of this could It's just gonna be back and forth, back and forth.
That's right.
Ms. Hutchinson, were you complete?
Yeah, I am.
Okay. It appears that all the commissioners have had comment. It appears that the applicants have had their comments. Mr. Lansing, do you have any comments? And we'll Mr. Thornton, but Mr. Lansing, if you do not have a comment, I do have a question. Mr. Lansing?
Yeah, can you hear me?
Now I can. Do you
Okay.
have any comments? If not, I do have a question.
Sure.
Question?
I'm sorry, I thought you said you had a question. I was waiting for
I
your
said,
question.
if you don't have any comments, I do have a question.
Yeah, I'm ready for it. I don't have any comments.
Okay, so it's been acquiesced and stated and pretty well noted, whether we believe or don't believe, whether it's accurate or inaccurate, it's not what I'm going to this point now. But take my supposition, if there was a verbal commitment from the county officials to put this project forward and you don't have to change anything, and it's like that the applicant said, are we bound to do it that way?
No. No, you're not.
Okay.
Yeah.
What in awkwardness legally?
No one can take away the discretion of the planning commission to approve or disapprove of an application. There may have been recommendations about how to go about that application made by Mr. David. But whatever was predicted or advised, none of that can bind the discretion of this commission to recommend or to decline to recommend. This is fully within your court to decide whatever recommendation you want and find appropriate.
Okay. I have a follow-up question, then the commissioners can chime in if they want to. Are verbal agreements by county officials in place at the particular time, standing agreements?
Not in this way, not in this context now.
Not in the context we have here. So, okay, that's what I wanted to know. Oh, okay, thank you so much. Any commissioner have any comments or questions based on that?
Mr. Chairman, I heard Mr. Marcantoni mention that there were some new plans that showed different road configurations. Mr. Hutchinson had brought up widths of roads, and somewhere in there I'd heard there were new plans. I mean, are there new plans? I mean, I'm going, I hope, I have a double screen thing going here, so I hope the public, as I'm looking off to the side, what I'm doing is reviewing the package on my other screen. But I mean, I can't even really read these plans, honestly. I mean, I can't read the numbers on them. I mean, it's really hard to tell exactly what's going on. I mean, if you've got new plans, I mean, why not submit them to us?
You have them.
We did submit the plans with the VDOT roads. They're 60 foot.
Are they in this package?
Yes, that was in our package.
The problem is
a new GDP that was dated 5/6/20 that everybody should have in their package.
Is that a site plan?
The problem,
general development plan.
Mr. Capel,
yeah,
and Mr. Marcantoni. Mr. Capel, this is what I really want to do at this point, just so that we can move along. The questions that you asked, let's ask Sandra, do we have those plans? We're not asking the applicant. I'm asking the applicant for now, in this session, part of the session. So we would ask Sandra do we have those in possession? That way, it would make it easier for us, because all they can know is what they submitted. They don't know what we have.
Yeah,
Sandra, do we have those plans?
Yes, you were given what was submitted.
You also
And the
have
same-
what we submitted last time.
Right,
Applicants, I'm gonna
that's
ask one more
correct.
time.
I had
Please do not
I had-
comment
I
at
had
all, or I'm gonna cut you out of the meeting. Go ahead, Sandra.
No, I was just gonna, as in response to Mr. Dudley's comment, I did include some of the historical information for your information, so that you could compare and see what had actually been approved in 2013.
Okay. Okay. Jason, do you have any further questions? Mr. Capel, I'm sorry.
I go by Jason or Mr. Capel. Yeah. I prefer Jason actually, but no, I don't have any more questions. You know, I've got 300 pages of stuff, you know, and a lot of things that I apparently don't understand, honestly. So it's very difficult to review all this in that short of a time. And then to hear all these back end deals and discussions, it frankly just irritates the heck out of me, really, because it's not the first time that we've dealt with this. And, you know, I would encourage you all in the future, you know, just the decisions are made at the, you know, in the public forums. You know, all this stuff in the background is like, I mean, maybe, you know, it's not binding. But anyways, listen, I'm going to do my best to look at this and try to figure it out. If you have information that you haven't presented, I mean, I would encourage you to send it to us. My view, Mr. Chairman, is we have until January 9th to figure this out.
Okay. We're going to end the work session on the rezoning of 20-01. We will leave everything as it is for this moment. I will talk with Sandra and Eric tomorrow or the next day to figure out our plan of action forward, where we will keep the dates we have or something different. That ends this work session. It's complete for tonight. Eric, Mr. Lansing, I'm sorry. Please go back to the public hearing 5A and 5B and give us the information that you found out, if you haven't got so cross-wired in your head to know what you asked.
No. And I apologize for interrupting right in the middle of your session when I came back from that phone call.
Fine.
I had thought that I had turned the volume back on and was wondering why all the commissioners were just sitting there so quietly. But
Which is not normal, huh?
I'm sorry.
Which is not normal, huh?
No, not at all. But Sandra is right. Conditions to a rezoning do have to be voluntarily proffered, which they have to be initiated by the applicant. But for an SUP, we can impose whatever conditions we want.
Okay, thank you. Going back to that, hearing that, if the commissioner does not have any questions for Mr. Lansing, I solicit a motion up or down for public hearing continuation rezoning 20-02.
Closing the public hearing?
Yeah, I've closed the public hearing. I'm sorry. The public hearing is closed. I'm going to work for the motion now.
On 5A.
5A.
I make a motion to approve.
Is there a second? Is there a second?
I'll
Chair will
second it,
second
Mr.
it for
Chairman.
the motion. Okay, Mr. Capel seconds it. It's been moved by Mr. Hutchinson, District 5, second by Mr. Capel, District 1. All in favor say aye.
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 Aye. Aye. Is there any objections or nays to the motion? State your name and say it. Hearing none, the motion is carried. Sandra, on this next one, you may need to, because it is SUP and there are going to be some requirements on it, that's just kind of how it rolls. Please attentively listen to the commissioners, either up or down, whatever they do. I solicit a motion for the continuation of SUP 20-03, which is the SUP that would be added to 20-02.
Mr. Chairman, I guess I would recommend approval with a list of conditions that were discussed during the discussion period, during the public hearing.
Okay, can you list them out for us?
Can Sandra list off those conditions?
That'll
Yeah,
be
I
fine
can.
if you accept it in your motion. Okay,
Okay, well, as presented with the staff report, we had the controlling document shall be the conditions set forth herein and the documents submitted with the application. Compliance, use, and development of the subject property shall be in substantial conformance with these conditions. The zoning administrator shall determine substantial conformance. The property owner shall be responsible for obtaining all required site plan approvals, building permits, health permits, VDOT permits, zoning permits, and erosion and sediment control permits. The property owner shall be responsible for complying with all local, state, and federal laws and regulations as may be applicable to the business development and operation. Number 3, uses. This SUP shall permit the operation of a self-storage facility as generally shown on the site plan and described in the application. And I think I would, reference in 1 and/or 3, just, reference the additional materials that were submitted that modified the original application. Under performance standards, number 4, A, per recommendation by the Culpeper Soil and Water Conservation District in their comment letter dated September 14, 2020, a site plan in compliance with the erosion and sediment control and stormwater management law and regulations is required. A no disturbance riparian buffer setback shall be incorporated on the stream along the west property line. This setback should be measured from the top of stream bank and be at least 35 feet. Exceptions may be allowed for erosion control and stormwater management and utility crossings. Underground.
Hey, Sandra.
Yes, sir.
Sandra, I hope to cut you off because I know you're on a roll. But on that particular one, is not where we had the clearing off the land and the cypress trees planted. Is that accepted?
That's the buffer. That was the I had thought that was the buffer, the rear and side buffer areas.
Correct.
That's fine. That's fine. I just want to make sure we get that part in there as we go with the motion. I'm sorry. Go forward.
Yeah, I'll look back at my notes when I get to that one.
Okay.
So, and then going on with that, the Culpeper stormwater recommendations, underground stormwater management practices are preferred to minimize the footprint of disturbance. The site drains into Lake of the Woods. Water quality protection is very important to the residents. Water quality treatment for the site development as required by the Virginia Stormwater Management Law and Regulations shall be satisfied on site. No off-site nutrient credit purchase should be allowed without due diligence to achieve treatment on site to the maximum extent practicable. Right, the next condition would relate to the buffer, and I don't have the exact wording here, but based on my notes, is that a minimum 50-foot buffer shall be maintained in the side and rear yards of the property. And this was where it would be worded to reflect that it would be either a combination of a 30-foot natural buffer with the planting of a single row of Leland cypress in the 20 feet of area closest to the fence that will be erected, or a clearing the total 50-foot buffer and the planting of at least 2 rows of Leland cypress trees. You discussed also a condition that the front landscaping will exceed the current requirements. Another condition under performance standards would be storage of motor vehicles, boats, recreational vehicles, motorcycles, etc. shall be screened so as to blend into the natural surroundings and not be visible from any public right-of-way. A parking concept plan for such vehicles shall be submitted as part of a site plan, and this area shall not be used to just satisfy any other parking requirement. Now, I recognize, just a comment here, I recognize that they have adjusted the site plan in such a way that these types of vehicles would be basically, screened by the buildings. But
Right.
so this shouldn't be necessary, and I would recommend leaving it, but I don't know that it's necessary, since we're saying that the revised site plan is a controlled document. So that one may not be necessary, but that was included in the original proposed conditions. And then number 5, per VDOT comments and email dated August 5th, 2020, additional information will be required prior to any site plan approval in order to assess whether turn lanes are warranted to preserve the functionality of Route 20 Constitution Highway. Trip generation at phase 1 and full build out using the ITE trip generation 10th edition must be provided, and a turn lane warrant analysis from the Virginia Department of Transportation. I'm sorry. I'm sorry, I lost. Well, I don't know what happened here. Oh, there it is. Sorry, got too many pages here. The turn lane warrant analysis must be performed in order to determine whether left and/or right turn lanes are required as part of the development.
Sandra, on that, should we qualify the fact that since they're bringing in large RVs and vehicles towing boats possibly, that they, because the extension of the tapered turn lanes might vary?
Right. So you're wanting to put something in the conditions that sort of go beyond the turn lane warrant analysis that's going to be required?
Yeah, I don't know what the length of the turn lanes are, but 250 feet used to be the standard. I have no idea what the VDOT requirement is, but it's got to accommodate large vehicles towing large vehicles.
Oh, right, yeah, and I don't know what that number is either, but I guess since this came from VDOT, I just have made the assumption that their turn lane analysis will determine the length that these.
If that's the case, that's fine. I just some of these short turn lanes do not accommodate.
Right, but I think they would take into account the types of vehicles that would be using the entrance. Number 6, landscaping shall not impair sight distance from the commercial entrance. Number 7, required entrance radii shall be determined based upon the types of vehicles utilizing the entrance. So, yeah. So there were those that would have been presented previously with the revision of the condition related to the buffer. Then
Well, plus there was one on the start time.
Okay, do we have to put the 6 o'clock time in there?
Do you want to add that too? Okay, all right.
And the noise signs, if Mr. Hutchinson would agree to those.
I fully agree with
Any
you.
other commissioner got a condition that we did not mention?
May I ask a question?
Okay.
Excuse me, Mr. Chairman, may I ask a
Sure.
question related to the condition
Sure.
about noise signage? Did you want to specify a number? I think something was mentioned about
We have
5.
five.
A
We have
minimum of
a
5.
minimum of 5 signs. One
Okay,
at the entrance and the exit. If the entrance and the exit is the same spot, then the sign would face both ways.
okay, so for ingress and egress, okay. Okay, thank you.
Mr. Hutchinson, based on all that she read and what's been discussed, do you accept that in your motion as a condition for the SUP?
I do, sir.
And Mr. Chairman, if I can just add a procedural note, since we're amending what's in the application with something added orally, this additional condition about the Leyland cypresses, I believe that's going to need to be provided in writing. It doesn't have to be fancy writing. So it's sufficient, for example, if Sandra just copies and pastes what she has for that added condition and emails it out to the commissioners, that'll be
Okay.
fine to affect Jim's new motion.
Okay.
But just the amended language will need to be in some writing.
Okay.
Well, it also needs a copy goes to the applicant as well.
That's right.
Yes.
That's fine. So we get both of those, we get that. Is there a second based on everything we've heard?
I'll second it, Mr. Chairman.
Mr. Capel seconds at District 1. All in favor?
I'm sorry, let me
Say aye.
clarify. It
Hold
needs
on.
to be received by the commissioners before the vote can be taken, is what I'm trying to say.
Okay. Do the commissioners receive the conditions on the SUP that's going to be sent out in writing?
I'm sorry to interrupt. What I'm trying to say is it needs to be sent by email to everyone. It needs to be something, a writing that everyone has access to before we can vote on the.
So we can't finalize the vote tonight?
No, you can't. No, you can absolutely do it tonight. You just need to take, 30 seconds to just copy and paste what Sandra just read as that added condition and just email it to the commissioners.
So you want her to email it right now?
That's right. And then we can take a vote.
Can you do that, Sandra?
Can you do that?
Not like the document has to be amended or anything like that. It's just,
So these are, the commission needs to see the conditions they're recommending in writing. Is that what you're saying?
the added condition that's not in writing yet.
Okay, so even though this was something from the staff report, this is not something from the applicants. It's not something they have just proposed tonight.
We're adding the condition.
We heard that we had a discussion tonight, of course, but.
Right, but we're adding the condition about the Leyland cypresses. Is that right?
Yes.
Okay, and that's part of the and the Leyland cypresses condition is not in writing anywhere. Is that, or did I get that wrong?
No, we previously had just in the staff report a condition that said a minimum 50-foot natural tree buffer shall be maintained in the side and rear yards. And we're proposing to amend that.
Okay.
So talk.
As Jason had suggested, right?
Yeah.
Okay. So that amendment to that would need to go out in writing to the commissioners, so that they just have some written
okay,
concept of the amended motion that they're voting on.
Okay, so as well as the additional condition about landscaping along Route 20.
Yeah, anything that's not in writing yet needs to be put in writing, and it needs to be accessible to the commissioners.
Okay, so that'll take me a couple of minutes. I don't know whether y'all want to go on to anything else while I'm doing that. I'm going to have to.
We are going to go on to something else, and we'll delay that vote. We're going to finish. We'll finish up else what we got. The question I have for you, Sandra, do you want to get Tracy to do that, and you stay with us so we can do this for potential text amendment?
Tracy, you've heard the discussion. Can you draft something and email it to them?
She's muted.
Tracy?
Tracy, are you there?
Tracy?
And if Tracy's
Tracy?
available, then Sandra, I'm happy to
Oh.
kind of speak for us both with regard to that zoning text amendment while you put that out there to the commissioners.
Yeah, okay.
Okay, all right, but then we'll move along with this vote zone.
Yeah. Okay, so Eric, if you're, is that how we want to proceed? Let Eric.
Yeah.
with
Let
you
her do B, and you try to get the email out.
Okay, all right, I will.
Okay.
Thank you. Eric, go ahead with B.
Okay, we're doing 6B, right?
6B.
Okay. So the impetus behind this was an inconsistency in our zoning ordinance that we have right now with regard to the authority of the Board of Zoning Appeals. The general policy of the zoning ordinance is that the Board of Zoning Appeals doesn't have any authority to grant special exceptions. But then there are 3 specific scenarios where they are given the authority to grant special exceptions. So we have a contradiction in our zoning ordinance that needs to be resolved somehow. So because we are, we can resolve that in either direction, either keep it and just allow the exceptions, or we can take away the exceptions. And what we suggest doing is eliminating those exceptions. So if you scroll down, we have this draft ordinance that just deletes those exceptions that are inconsistent with the general policy of the zoning ordinance. And those are set in a number of different zoning districts. They're in agricultural, they're in residential, they're in general residential, but in all of them, it just says that the zoning administrator can make a call to waive the setbacks for porches. And if he doesn't make that call, then his failure or refusal to do so, then it can be appealed to the Board of Zoning Appeals. And that's not really the general purpose of the Board of Zoning Appeals. Generally, the Board of Zoning Appeals deals with variances, not special exceptions. So we're just taking that out from all 3 of these setbacks and yards provisions, all 3 of those sections in all 3 of those different zoning districts.
Eric, do we have to hold a public
Any
hearing
questions
on
by
this?
commissioners?
Jim, I heard the beginning of a question.
Do we have to hold a public hearing on this change?
Yes.
Any other questions from any other commissioners?
I think Jason's talking.
Yeah, sorry, Mr. Chairman, you're just looking for concurrence from the commission that this should be moved forward to public hearing. Is that correct? Or discussion?
That's all I'm looking for.
Yeah. So based on
don't need
Mr. Lansing's recommendation, my suggestion is we just go ahead and move it forward.
That's kind of where I was at.
Sure.
Can you get this set with Sandra? Eric, when you want to put it on the public hearing agenda?
Absolutely, Mr. Chairman.
Please do me a favor, though. Don't set 4 or 5 of them the same night.
I'll do my best.
We started at 6 and we were rolling on pretty heavy here tonight. I didn't even give a break.
Sure.
All right, now we're going to number C, subdivision waivers. And that was a memo from Eric in September.
Sure. And the context, I don't know whether it's really best for me to give this introduction or for Jason, because he initiated the idea for this. But essentially the background of this is that there is a right that an aggrieved party has to appeal the subdivision agent's decision to grant a waiver of any provision in the subdivision ordinance. And when I hear about an aggrieved party to a waiver, what I would ordinarily think of is that the aggrieved party is the applicant for the waiver, and he's aggrieved because the waiver was denied. But when you think about it, I mean, that's not what the subdivision ordinance says. It's much broader than that. So we really need to think about who else might be aggrieved by the granting or denial of a waiver. If there's someone other than the applicant, how do we know when they get notice of the waiver having been granted or denied? Because a lot of people who are aggrieved aren't necessarily entitled to the notice. Jason asked me to put together two projects. One is to find out when the subdivision agent has the authority to grant waivers in the first place. That kind of provides an important procedural background to this. As you may remember, there was a 2010 overhaul of our subdivision ordinance that radically restricted the authority of the subdivision agent to grant waivers. It used to be that the subdivision agent had pretty much any authority in any situation to grant a waiver as long as certain criteria were listed. But in our current subdivision ordinance, subdivision agent only has authority to grant a waiver in specific situations. And those are laid out in this table right here. 5 situations where it's a waiver, a modification, or some sort of situation where we're departing from the general rules of the subdivision ordinance is granted to the subdivision agent. And this ties really closely with the draft ordinance that we have right here, which proposes certain it proposes a zoning text amendment that would allow us to basically know when an aggrieved party is notified, and that's how we know when to count the clock for the appeal deadline. But I'll pause there before I describe the zoning text amendment to let everybody catch their breath. And are we all on the same page there? Any questions? Jason, you want to fill anything in?
Seems like none, move on.
Okay, great. So what this zoning text amendment does right here is it provides 4 scenarios where notice is received by someone who's an aggrieved party. It just says, well, actually up there at the top, we're on page 46 of the agenda. If you look at subsection A, it adds this text that says that whenever a waiver is granted, the subdivision agent has to notify the planning commission along with the applicant. And the agenda for the next planning commission meeting has to include a notice of that waiver. So that allows for not only the planning commission to know, it allows for the general public to know. We could have taken this a step further and required letters to be sent to all the neighbors and so forth. If that's the pleasure of the commission, then I could take it that step further, but this zoning text amendment doesn't go that far. And then in subsection D, it just defines what notice is. And it just says, you know, in the case of the applicant, if he's the aggrieved party, then he receives notice when he's notified of the subdivision agent's decision. I mean, that one's the obvious one. For D2, the planning commission is notified when it receives that mandatory notification in subsection A. And for D3, for basically the rest of the general public, they're deemed to be notified when the notice is put in the planning commission's agenda. So that's kind of our recipe for having an easy way of knowing when the notice is received. And then finally, in D4, it just says that actual notice also counts. And as I was reviewing this earlier, I realized actually that last line, regardless of any of the foregoing notice provisions, what I really should have in there instead is it ought to say, but only if the aggrieved person receives such actual notice prior to any of the deadlines described in paragraphs 1 and 3. In other words, the idea is if you receive actual notice before the deadlines listed here, then you're considered to be notified. So it's from here, the commission can just discuss whether this is necessary or whether it's considered an improvement. And I'm happy to take any questions y'all have.
Mr. Capella, I'll let you go first since you were the person who brought it to the commissioner who brought it to our attention.
Well, I just want to thank Mr. Lansing for putting it together, and you know, just for the sake of transparency, I just feel like, you know, we ought to know when a waiver's granted, and that's it. And I think this does, in my opinion, it gives us a chance to know, and it gives the public a chance to know that a waiver was granted.
Well, any other commissioners have a comment or concern, or should we go forward in this process? Hearing no other commissioner, what would it have to take to put this into as a part of our policy?
The same as the previous one.
Right.
Same as the previous zoning text
So
amendment. It would
Okay.
need to have a public hearing and be advertised.
Can you see if you can get those two on our agenda with Sandra's help?
Absolutely.
Okay. It looks as though I've received mine. Has every commissioner got theirs in writing?
I have it.
You almost got to have 5 screens to keep up with these Zoom meetings, so I get it. I've got mine. District 5 has his. District 2. District.
Is it in the form of an
Julie,
email?
you have yours?
Yes.
Email.
I do not have it.
Email. He's got
I
it.
do not have it.
You do not? Okay.
Do not.
Julie, do you have it? She's looking. I can't hear you, Julie. I see your mouth moving.
Does the 6 a.m. Requirement have to be done in writing also?
I'm sorry.
Mr. Chairman, mine just showed up.
Okay. Yeah, the 6 a.m. is out.
I have mine. You can hear me now?
Okay. Okay. She has hers. Mr. Capel? Neither is the noise in here unless I'm missing it.
Good to go. Good to go, Mr. Chairman. Good to go.
Okay, let me, can you hear me?
Okay. Yes.
You can hear me? All right, let me add those. I just was so focused on getting the landscaping stuff correct. I forgot, I didn't look at my other notes. So let me go back and add those 2 things so you can see those too. It'll be quick, I think.
Okay. Okay. Eric, do you know anything about the county complaint process, or Jason, do you know any more? Looking at
Mr.
6D.
Chairman, I've not done anything else on that. My intent is to reach out to Mr. Voorhees and just chat with him about, you know, basically just getting some sort of, I'm thinking like a category added that it can be marked as a potential land use complaint, just so we can get visibility on those. but I also honestly want to talk with him about phone calls and, you know, how those are actually documented, because it doesn't sound like they're really documented. It sounds like maybe they're documented, maybe they're not. And they get handled in email. So if someone were to call and complain about fireworks, for instance, you know, that might go to a person who then types an email and sends it somewhere. But there's no way to really know that that complaint happened. So I just want to see, it's really going to come down to what Mr. Voorhees is open to. If he's just open to it and the changes are easy, you know, great. I can bring that back to you guys for consideration. If he's not open to it, then we would just need to discuss how important it is to us and what we'd like to do about it, if anything.
Okay. But Mr. Capella, I would ask not to put it on the 5th agenda. It looks like that agenda is filling up pretty heavy right now. And if we put it on the 5th agenda, we just may not be able to get to it and work through it.
Well, I'm pretty sure the chairman has full authority to put it on the agenda, whatever you like. So I'm fine with that, sir. We can put it on whenever you'd like to, but I will follow up with Mr. Voorhees.
It's not important, but these meetings, like to try to keep them within a 2 to 3 hour space if at all possible. Now, does any other commissioner have any old business? Mr. Johnson, do you have a report for us? We're going to skip over Sandra's report until she comes back. Any commissioner have any comments? District 1, Mr. Capel?
I'd just like to reiterate my opinion on the virtual meetings. There's still some question as far as transmissibility and temperature and the seasonality of the viruses. You're seeing increase in cases, and people aren't really sure if that's due to people's behavior changing or due to the environment that the virus transmits in changing. And I think it would be prudent for us to get through the cold weather and get through the holiday season, and you know, perhaps at the beginning of the new year, reevaluate the situation. I think we'll all have a very good idea of where we are then. That's all I have, Mr. Chairman.
Okay.
Bottom line, to continue virtual until then.
Mr. Yancey, District 2.
I concur with Mr. Capel's comments in that reference.
This 3, I have two quick things. Mr. Hofsteller, I don't know if y'all received a letter, thank you from him, but he sent one to me and I thought it was very well accepted, considering what our recommendation was, a handwritten note of thank you. We don't get a lot of those, but to get one of thank you from him. If you all didn't get, he passed it along. He thought the commission does good work and that we did our due diligence with him there. I think it shows the class of a person he truly is. The second thing, I just want the commission to know I'll be calling Mr. Lansing sometime tomorrow and discussing some of the allegations that were made tonight and how we can make sure we don't go down that road again. That it's a little bit disturbing to hear commitments that we can't follow through with, and I won't go too much into it, but I will be calling Mr. Lansing, who then will give me instructions on what he thinks, and probably will be following up with a conversation with both the county attorney senior and the county administrator. I think this needs to be caveat on. If somebody has a problem with me doing that, please tell me. All right, looks like that Mrs. Thornton has sent an email to me, but I'm not going to that right now. The next meeting will be November 5th. And now we'll go back to Did everybody get the email from Sandra on the additions that she left out before? If so, if you didn't get it, say I didn't get it. That'll make it easier. I will assume you got it. All right, so then that takes us back to 5. Wow, I forgot where I'm at myself now. It takes us back to 5B, is that correct? Mr. Hutchison from District 5 had a motion on the floor to approve the SUP, seeing all the conditions that have been sent to you in writing. Is there a second?
Mr. Brooks, I seconded that previously, and I'll second it again.
Mr. Capel seconded previously, and the reason I didn't say that is because we didn't have it in writing, so I want to make sure we were correct on our procedure. So it's been moved and second with the conditions that we approve this with the conditions that's been stated to us in writing and in our hearing. All in favor say aye.
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 Is there any opposition? You have likewise. Hearing none, it passed unanimously. Mrs. Thornton, thank you for your work. I would ask you also, Mrs. Thornton, while you were off, we have about 700 things. No, I'm just kidding. We have 2 things that you need to get with the county administrator on. That's B and C, to get those public hearings together for us, to get them on the next dockets.
So Eric got a promotion.
Yeah, okay. County
I said
attorney,
Eric
I'm
got a
sorry. I said county
promotion.
administrator.
Yeah.
Yeah,
I had my ear on what was going on. So.
All right. So
Yeah.
Get with Mr. Lancy on B and C to get them on our agenda. And do you have any report for us?
Mr. Chairman, I'm sorry. I don't think we actually took a vote on authorizing those for the zoning text amendment and the subdivision ordinance amendment on authorizing them for a public.
Oh, we got to take a vote to put them on the agenda?
I believe so.
Oh, yes, I think you do. Yeah.
Okay, well, I solicit a motion for B and C, 6B and C, to be put on the agenda at the earliest convenience.
So moved.
So moved. Is there a second?
Second.
It's been moved and second that they will be put on the agenda for public hearing at the earliest convenience. All in favor say aye.
Aye.
Aye. All opposed? Just for clarity, Ms. Zolmaker, I did not hear your voice.
Can you hear me?
I can hear you now.
Okay, I said aye.
Okay, that's to put them on the agenda. Thank you so much.
Yes.
Okay. Mrs. Thornton, do you have a report?
I think I would like to just let you guys know that we paused our, I guess, more typical planning related activities last week to assemble the required notices that have to be sent to owners of properties proposed to have their flood hazard designations changed by FEMA. So that did take a bit of time, but I think that with the help of county administration, that process is being completed. So those notifications will be going out next week. And we have specified November 25th as the date to receive comments if owners wish to appeal the changes being proposed for their property.
Understand there's a number of those going to Lake of the Woods.
Yes, I believe it's over 800.
Yeah.
I think it was,
Okay.
it was a little in excess of 2,500 cards that were being mailed or will be mailed next week.
The impact, as I understand that, is that for those that pay cash for their property, that own it outright, they do not have to acquire government flood insurance. For those that have a mortgage, they have to insure it.
Yeah, I think usually mortgage companies do require flood insurance. Yeah,
So it's going to be a cost to a lot of homeowners.
yeah.
Okay, anything else, Mrs. Thornton?
Just, I mentioned this a couple of weeks ago. The interest in solar development continues. So we will be pursuing, the recommendations to maybe look at the regulations of some other localities to see, how whether there might be some ways to enhance our review process.
Okay. Thank you so much. I solicit a motion to adjourn unless we have something else that claims our attention.
One very last thing, Mr. Chairman. We had mentioned doing a letter, I believe, for Supervisor Goodwin. Were we able to do that, or was that just a resolution that we had done?
We were supposed to do that, and I don't recall signing it. I'll check into that.
Thank you, sir.
Thank you for that reminder.
Mr. Chairman, one other comment, and then I support Mr. Capel's request to continue. As much as I hate doing these virtual meetings, but I'm still in a high-risk situation.
Okay. The chair can do it either. I'm just wanting to convey information. I was also told that we pretty much could do what we wanted to until the end of the month, but the end of the month, if the law doesn't do something, I'll find out what we're doing. I'll just leave it at that. I'll find out what we're doing, because if the law changes, then we have to change with the law, but I'll find out what we're doing. I think you're going to find the law being pushed down the road a little bit further, but we shall see. Okay? Again, I solicit a motion to adjourn.
So moved.
Is there a second?
Second. Second,
All in
Mr.
favor,
Chairman.
say aye.
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 Aye. Appears we have enough to close. Thank you so much for your time and attention, and thank you for what you do for Orange County.
Hey, Sandra?
Yes.
The plans for Signature Station, I don't think I've received them.
You didn't receive the plans with your
I've
agenda
gone
packet
through.
we didn't resend them this month, but you didn't receive.
Oh, I have the old plans.
Yeah, we didn't I mean, they didn't submit any new plans. I mean, we didn't have any new information from the first other than the letter that I had written.
I have that. It was my
and then-
understanding that they had submitted new plans, and
I think they were saying, I think what they were meaning was that they were new compared to what was approved in 2013.
well, I mean, that was the whole thrust of the discussion.
Yeah, I mean, they said that they had plans dated 2020, and then I asked if we had we been sent those, and the answer was yes. And I mean, maybe I've missed them, but I mean, I've looked at these 300 pages probably 4 or 5 times now. Maybe they're in a separate file. I don't know, but I don't see them.
I don't see them either.
And I've been wrong before, so.
Well,
They were folded pages that I included in the packet, in that 300 and some pages.
371 pages.
Yes, sir.
That I have earmarked here, but I swear to God, I mean, I see a development, page 13 of 20, that Welford did, but that's dated 2013.
The plans that, and I have them in my package, they're folded too. It says up in the left-hand corner, upper left, issued for generalized development plan, date issued March 27, 2020. And then the engineer's certificate in the lower right is dated June 5th, 2020.
I don't have that.
If I could get that one again, if it's in the 100 page,
Julie, I couldn't understand your question. There was a lot of, you were really breaking up.
Sandra, this is George Yancey. I have that. The only question is, it's such small print, it's very illegible.
I can't argue with that. It is kind of difficult to work with.
I can get copies of these made and out to everybody if they're not being able to see them. What I have is on a 11 by 14.
Would you do so, please?
Absolutely, but I thought that I included that in the packet and the pages were folded in half so that they were all the same size.
I don't have
Hey, Tracy, when you,
I think
Tracy,
they're
when you say,
11 by 17 sheets, actually.
17, yeah.
are they in the electronic version?
Yes.
They have to be.
Yes, that is correct.
Oh, not in the one package that was delivered.
Well, I've got a copy of the deed from 2003 in my packet. I have a rezoning application supplemental information
I got that.
memorandum. I have, as Mrs. Thornton alluded to, the generalized development plan dated March 27th, 2020. There was a memorandum from Bowman Consulting on trip generation dated 11/18 of 2019 in the packet.
Jason, if you look electronically at page 32 of last week's agenda,
Okay, I'm at 32 of 271.
Yep.
Oh, the generalized development plan.
That's it. If you look in the, if you have to go down, but in the bottom left corner is where it says date issued March 27th, 2020.
Yeah, okay, okay, all right.
So it looks weird because it's like one page or one half on one page, one half on the next page. Because it was a double fold.
Yeah, okay. I mean, I just can't tell, I can't read most anything on here. I mean, so, okay, well.
And I'll be glad to get these other copies out, but they're just as hard to read.
Excuse me.
Well, I'm thinking the chairman had indicated he would talk with Eric and me tomorrow about how we move this matter forward, and it sounds like one of the things that we need to do if this will be coming back to you, which we imagine it will, is to ask them for a larger set of plans.
Current plan.
They don't need, they don't even need to be larger. They just need to be legible. I mean, you know, it's crazy because these are all CAD drawings. And like, this is 2020. Like, there's no excuse for them to submit plans like this. I mean, I generate legible plans all day. It's literally a PDF right out of the daggone program that they're using. So I don't know what they've sent here. These
Yeah,
look like
well-
scanned versions.
Well, what you got, I mean, and maybe that's part of the problem. I mean, what you have are scanned if you, in order to send them to you by email. So looking at an original set of plans, I mean, it's small, but you can read the information.
Yep. Okay. Well, I mean, they should just send us a PDF of these plans. They'll be perfectly legible. You can zoom into them. You can see everything on them.
Okay.
And I know whatever program they're using here may not have the seal on it, although that's probably digital too. But I mean, all right, well, my bad. I mean, it like I can't read the dates on them. So, I mean, to me, they just look like the other old plans that are in there. So, okay.
Thanks, Sandra. You've done overtime and it's not over.
No, it's not a, well, you guys have too. So we just can't carry on.
I know.
Bye, everyone. Thank you, Sandra. Thanks, Tracy. Thanks, everyone
Thank
on the
you
line.
all.
Appreciate it.
Good night, everybody.
All right.
Good night.